All right. Hear ye. The Court of Appeals of the State of Michigan is now in session. The Honorable James Redford, the Honorable Michelle M. Rick, and presiding, the Honorable Michael F. Godola. All persons having business herein draw near, give attention, and they shall be heard. God save these United States, State of Michigan, and this honorable.
Good morning. I'll try again. Good morning. Okay, much better. All right. I haven't had to do that in a long time. So on behalf of my colleagues, Judges Redford and Rick, welcome to the Michigan Court of Appeals. This is panel 2 in Detroit. First day of our 2-day case call. I'll give my usual advice and admonitions to the lawyers. We're very well familiar with all the cases we'll be hearing today. We've had reports from our staff. So we know the fact, and we've read your briefs, of course, we know the facts of the cases. You don't need to dwell on those, just cut right to the most decisive legal issues and let us know as succinctly as you can why you think you should prevail in your appeal today. In cases involving minor children or protected individuals, please know proper names, just initials only. We're recording the arguments today and they'll be uploaded to YouTube within the next 24 hours. So bear that in mind as well. I think with that, I can call our first case of the day. That would be item number 1, docket number 364516, People of the State of Michigan versus Cedric Lynn Wyndham.
Good morning.
Good morning.
May it please the court, Ali Wright from the State Appellate Defender Office on behalf of Mr. Wyndham. There's several issues raised in Mr. Wyndham's brief on appeal, but I'd really like to devote argument or focus my attention on the first issue. But of course, if there's any questions from the court on any of the other issues, I'm happy to attempt to field them.
Sure.
I really see Mr. Wyndham's cases, the way I see it, is really how we treat our aging veteran population when they have no priors and are provoked into a situation where possibly due to some underlying undiagnosed PTSD, they snap. And Mr. Wyndham, no doubt, was convicted of a very serious offense here, assault with intent to murder, but there's no getting around that. And we're not offering excuses for that. He seriously hurt 2 people. But there's still the question of the extent of his punishment. And it's to this court to determine whether Mr. Wyndham's sentence is reasonable and proportionate, and specifically whether it accomplishes the sentencing goals of rehabilitation, protection of society, and deterrence. And when Mr. Wyndham's background is properly considered, it becomes clear that sentencing him to virtually the top of his guidelines, and specifically his 18 years out of a possible 18.75 years, which is within 90% of the most he could get, does not achieve those goals and is not reasonable or proportionate. Mr. Wyndham served nearly 15 years of his life in military service to our country, and until he was honorably discharged owing to a serious injury.
Was he on a medical disability from the Department of Veterans Affairs, or was he medically discharged from the armed forces?
My understanding, and I think my understanding is he was medically discharged. I know he was in a very serious car accident, and I think that prevented him from continuing to be able to serve. And as a result, he was honorably discharged. I'm not sure if that answers your Honor's question.
It does not.
Oh, I'm sorry.
I was aware of that.
Okay.
As my colleagues know, I had the privilege of serving for 28 years in the Navy, and there's a process by which veterans who are injured or have physical maladies or PTS related to service, you apply to the Department of Veterans Affairs, you seek and sometimes obtain veterans disability rating. It can have financial remuneration at any rate. And I looked throughout everything in the file and I just couldn't ascertain whether or not he had a recognized disability rating with the Department of Veterans Affairs.
I won't be able to specifically answer your question, but I can offer that I know that Mr. Wyndham was receiving one, he would go to the VA for healthcare and he gets those benefits as well. And then 2, I know he was receiving benefit checks from the government. So I do know
You know
that.
how much it was? Because there's if you are a veteran and you don't have financial means, you can have what's called aid and dependence that the
Sure, and I
state
don't think
gives.
it was that. I know he was receiving. I want to hazard it was just it might have only been Social Security benefits, but I also think he was receiving. I know he was receiving benefits from the government. I'm sorry, I can't answer.
Okay, all
Your
right,
Honor's
thank you.
question.
That's right.
Of course, if it's helpful to the court, I'm happy to supplement.
I just looked in the record. I couldn't find it in the PSI.
It Mr. Wyndham, after transitioning to civilian life, Mr. Wyndham spent the next 30 years or 3 decades or so as a law-abiding citizen, a productive member of our community. He became a grandfather. He did not commit any offenses, and he worked an honest job, which is why his case is sad for everyone involved, not just the people who he hurt, who have to live with those injuries, but also for himself, given that coincidentally, the day this offense occurred was the day Mr. Wyndham was supposed to retire. It was his last day of work, and he looked forward to spending time with his partner, traveling and in retirement, enjoying his retirement. And obviously, this happened after years of work and working an honest job, and now instead he is likely to die in prison. I think it's also important to remember that the complainants were the initial aggressors here. They came to Mr. Wyndham's workplace. They started this argument with him. They threatened to harm him. And Mr. Wyndham, given with his background and possibly undiagnosed PTSD, he admittedly snapped in response to those threats. But afterwards, he surrendered himself to police. At sentencing, he expressed remorse for what he did. And he explained that he was trying to get rid of what he perceived to be a threat. And given his military background, I always find those words from him very interesting in the transcript, trying to get rid of the threat.
Is there any evidence in the record that your client either served overseas, outside of the continental United States, or in combat?
No, my understanding is he was trained and he did not deploy to Kuwait or anything like that.
No. He was discharged in 1995, so it was the Persian Gulf War One started on 2 August 1990, so he could have been deployed for that. Was he deployed for that?
He was not. He was not deployed.
All right.
In any event, Mr. Wyndham's sentencing guidelines, and we're looking at 11.25 to 18.75 years. And in looking at the reasonableness of the trial court's decision, this court should ask itself whether it was reasonable for the trial court to give Mr. Wyndham a sentence towards the top of that range, specifically within 90% of the top. And given the mitigating circumstances relating to Mr. Wyndham's background, his military service, his lack of any priors, his age, his poor health condition, and the reality that an 18-year prison sentence is essentially a de facto life sentence for him, a sentence so close to the top of his guidelines, 18 out of 18.75 or within 90% of the top, is not reasonable or proportionate.
If I could just follow up on Judge Redford's question, I too am struggling with his prior service and how that prior service was not combat related. I mean, what is in the record that would perhaps justify or bolster the claim that's being made here? Because candidly, we will see people from time to time in our cases who, we are appreciative of everyone who puts themselves before country, hands down, full stop. But it in my mind anyway, it seems that those who were deployed in combat, that their argument would be stronger. So can you help me find pieces in the record to validate the claim as it pertains to proportionality.
Absolutely.
And just as a follow-on to Judge Reich, I was never in combat. I was overseas a lot. I was at sea a lot. Had very startling things happen to me sometimes. But if I were seeking to do what the accused is seeking to do here, I would say here, when I was fill in the blank, this is what happened. And that's why I'm asking for leniency. And I'm just not seeing it in the record.
So to address both of your Honor's questions, I think 2 points. One, I'd just remind the court that there is a motion to remand in this case, and the purpose of that remand would be to supplement the record with precisely kind of what your Honors are asking for. There was an affidavit, I believe, submitted by Mr. Wyndham's partner talking about his struggles in this department at night. We also have Mr. Wyndham's records from his military service, and those are things that I would like to put in the record, but a remand to the trial court being necessary to do that. Potentially testimony from an expert or Mr. Wyndham too can all supplement exactly these questions that the court is asking today, which is why we're asking for a remand. So that's one point. I believe the second point I wanted to make, and I believe Judge Redford, you actually kind of went to my point a bit. Judge, I agree, Judge Rick. If Mr. Wyndham may not have seen, let's say, active combat in what we think in terms of active combat, but it's my understanding, and again, a remand would be helpful here. Between he did have certain experiences during training, during when he was training in the Army, that have had potentially a lifelong impact on him, and I'm sure. As Judge Redford can attest to, I'm sure everyone in military's experience is different, but military training is military training. They're training you to do a certain thing, and you can have certain experiences in that training that would potentially leave an impact on you mentally.
Thank you.
Thank you. So just to kind of wrap, the sentencing Mr. Wyndham to effectively die in prison will not rehabilitate him. Him serving.
You do have pretty aggravated circumstance. I mean, you have the victim lying on the ground, torso down, face down, and the evidence of record sounds like he then discharges another round into one of the victims. I mean, that is bad facts as far as the aggravating circumstances.
Mr. Wyndham,
Those are bad facts. I'm sorry.
I can't say it's helpful. Mr. Wyndham did testify that the reason he discharged a second shot into the victim's leg there was because he thought he was crawling towards the saddlebags of his motorcycle to get a weapon, and that he shot him in the leg to prevent him from moving further. Again, I'm not trying to justify his actions. I'm trying to explain why he said he did that. And I guess Judge Redford, you, I guess, were speaking about what are we, are these aggravating factors? And again, as the court is aware, we weigh or measure the offense itself as well as the background of the offender. And Mr. Wyndham's argument here is that when you properly weigh his background against the offense, and you look at this range, something within 90% of the top is not reasonable, it's not proportionate. And I think that's particularly so given his age, his health issues, his military service, and we'd be more than happy to put even more evidence in the record so that this court can make an informed decision of that should it remand. Okay. So I just close with, Justice Welch, I saw wrote a few months ago in a dissent in People v. McSorley, as MSC number 168210, that she's concerned that Posey is toothless. And I think Mr. Wyndham's case is an opportunity for this court to show the Michigan Supreme Court and Michiganders that Posey is not toothless. It's not reasonable and proportionate to sentence someone with Mr. Wyndham's background, a 65-year-old honorably discharged veteran with no priors, virtually to the top of his guidelines when he was provoked and was not the initial aggressor here, when he was provoked with threats of physical harm until he snapped. So Mr. Wyndham asks that this court remand his case for further evidentiary development and or sentencing, and he otherwise rests with respect to the other claims raised in his brief.
Okay,
Thank you, Mr. Wright.
Thank you.
You'll have time for rebuttal. Smith.
Good morning to the court. Amanda Smith, Wayne County Prosecutor's Office, on behalf of the people, the appellee in this matter. I did not check this before I came up this morning, but I fear that I filed one of my long briefs in this case and filed a motion to extend the word limit. I may have done that because I felt there was a lot of ground to cover. And I always kind of go back to what I think Justice Scalia once said when he's reading a brief. He wants to see everything in the brief. So if you cite to a statute, you look in the footnote, statute's right there. And that is my policy when I write. I want it one-stop shopping, and you can find everything you need in what I filed in court. And with that said, for issues 2 through 4 that are for this court's consideration, I would rest my brief unless there are any questions there. I anticipated, and I'm not surprised to hear that we're here today to really talk about issue 1, which is sentencing. And as I've already said, I think I really ran the ground on that issue in my brief and well covered it. But I do want to reorient the court a little bit on that issue. One is my position and the people's argument that Posey is not binding. It's a plurality opinion. This court has authority that indicates that you don't have to follow Posey. I understand that panels of this court have decided for judicial economy and for the sake of keeping everything kind of on an even keel, the court is following Posey. So I'm not really fighting the hypothetical, but I'm just putting it out there.
Has your office or any other prosecutor's office sought to have the Supreme Court address that head on?
I'll take this case. I mean, I'm making the record. I same thing in my issue 4.
Mr. Wright, you ready for that?
I've seen Mr. Wright, argue in the Supreme Court. He is a formidable opponent. I'm sure we're ready to go. Just like in issue 4, I make the argument about People versus Davis, in my view, being wrongly decided for the reasons that Justice Zara indicated in his concurrence in that case. I'm prepared and I would love to take that issue up, but I'm limited to the cases that
Really?
I appear on.
I think to Mr. Wright's point,
Mhm.
I'm not aware of a successful Posey argument being made in this court. I mean, maybe it's happened.
That a panel has decided not to follow Posey.
Has
said it's
decided that a
Yeah.
within guideline sentence is disproportionate.
Oh, I see.
That's so, I mean, you're winning under the current regime. And as Mr. Wright also helpfully pointed out, Justice Welch, I think understandably has expressed her concern that
Sure.
Posey might be toothless. I don't know that I'd want to give the Supreme Court an opportunity to make it not toothless if I were in your shoes, but
Listen, we're on the record, so I'm not going to get into the odds of the people prevailing when we take cases up.
Right,
However,
right.
I do think it's important to think about, like, what are the sentencing guidelines for? Why did the legislature enact them in 1999? I think was their effective date. They were to bring uniformity to sentencing, so that
Would you agree that the sentence is, for someone with no prior felony records,
Mhm.
a fairly substantial sentence?
So I do address that in my brief. PRVs 1 through 6 were scored at 0 points and it reflects the lack of criminal history. PRV 7 was scored at 10 points. That's to reflect the fact there are 2 AWIM convictions here. So he only had 10 PRV points. However, his OV total was 140. And the OV total otherwise would have maxed out at 100 points. So he went 40% over that OV total. And I don't recall the name of the case I cited in one of my many footnotes in issue 1, but there's a specific case from this court that indicates, the legislature didn't really think about a person with 0 criminal record, therefore very low to 0 PRV points, and having 140 or 100 plus OV points. They didn't really think about that. So when you think about it in that context, the fact that Mr. Wyndham, yes, he did receive a sentence at the top end of the appropriately scored sentencing guidelines, it truly didn't even contemplate the actual nature of those OV points. I mean, really, the 140 points versus the 100-point max. And I very much hope I did deliver a copy of the video to this court because the video is critically important. As they say, a picture is worth 1,000 words. That video is worth 1,000 words.
But when we train young people to be killers, and that training takes here, not abroad. I mean, it's horrific, but I don't know. I'm intrigued about whether this trial court had the sufficient record based on the accused mental health experiences in the military, et cetera. I mean,
Sure.
you got to give it some perspective. It isn't like it was my grandmother committing this act, which would be off the charts horrific. And this was for these victims, and I don't want to minimize that. But again, I think context is important.
I agree with you.
And do you think that there should have been more information provided to the trial court?
So if we're looking at what the court has in the record, 7210A, I believe is limited to the record. Is there anything in this record about Mr. Wyndham suffering from PTSD? No, there is not. The Appendix B, which is the affidavit or offer of proof offered by his live-in romantic partner, as a layperson, opining as to she feared perhaps he did have a mental health issue that was never admitted in the record. I guess I understand that it is an offer of proof for remand. However, I did direct this court in the first section of my brief to the PSIR, where they interview Mr. Wyndham, they ask him about his physical and mental health, and they do a whole separate section on physical and mental health, and he did not report any mental health issues.
Well, and I was looking for a document called the DD 214. That's the certificate that an enlisted person receives when they leave each term of service.
Mhm.
And it records and memorializes where they served to a certain extent, but it also then tells us what are their military occupational specialty. It also tells us what their personal declarations are. And unit decorations. So it gives you so much more insight into what the background of the service member, but I didn't see it anywhere.
It's not been offered.
Right. And I mean, so anyway, it's.
The PSIR indicates that Mr. Wyndham, and again, as this court is, voice, I'm sure we all agree, we respect military service. It's a wonderful, tremendous thing to do. My father served in the military. I was born on Air Force Base. I understand that.
Well,
However,
the Air Force is not a constitutionally recognized force, so your dad really
but
wasn't.
Air
in-
Force, I get it. I did ROTC as well for a hot minute there. In any event, I understand that we respect the service. However, I'm limited to the record that we have. The record indicates in the PSIR that Mr. Wyndham was a supply sergeant in the U.S. Army from 1978 to a medical discharge due to the car accident in 1992. I believe I have those dates right.
It's right around.
Thereafter, he worked for a doctor in Berkeley for many years, and then he had this position working at U.S. Quality Market that led us to the events of the incident offense in October of 2019. There is nothing in this record, and there's been nothing offered as the offer of proof for the remand other than the affidavit or offer of proof from his live-in romantic partner that remotely suggests anything related to military service had anything to do with what happened on the day of the shooting. And I would bring back to, again, so if we're going to apply Posey, which I understand panels of this court have, we have to presume the sentence he received, which was within the guidelines, is proportionate and is Mr. Wyndham's burden under People versus Sharp 192 Mishat 501 1992 to show this court unusual, rare circumstances that make that guideline sentence disproportionate to him. And I cited as an example People versus Cole, an unpublished opinion from this court from 1998, a panel of this court holding that veteran status is not unusual. And that is not an unusual circumstance because, as Your Honor, my father, many Americans have served in the military. So veteran status by itself is not an unusual circumstance. Other circumstances listed in the brief filed by Mr. Wyndham include being a grandfather, being a person of, 60 years plus age. And again, circling back to what Judge Heisey did in this case, she did consider all of that material that was presented to her. in the PSIR from Mr. Wyndham himself when he gave his allocution at sentencing, she did consider his physical health as well. This is not a case that anyone was happy about. She felt for Mr. Wyndham, and she said that at sentencing. And, you know, going to the abuse of discretion standard, which is very much what applies here, the trial court, Judge Heisey, sitting as the trial judge in this case, sitting as a sentencing judge in this case, was really faced with a tough decision. And she made that clear. She really thought a lot about the sentence in this case because fundamentally, nobody was happy to think about this gentleman going to serve time in the MDOC. But she brought the case back to what happened to these two people at the market on that day. What did the video show? The video was egregious. And what really struck me when I watched the video is that the management of the store were physically trying to restrain Mr. Wyndham, physically trying to hold him back when he pushed around one of the managers and fired a gun point blank range into Mr. McElrath's chest. Turned around, shot Mr. McElrath's romantic partner, Miss King, in the neck, and then continued on to Mr. McElrath and shot him in the back of the leg, penetrating both legs and then breaking a bone in the second leg as Mr. McElrath begged for his life, saying, "Don't kill me, I have 7 children." That's what happened in this case. And it is terrible for everyone involved. But again, Judge Heisey considered all of those factors and came to the conclusion that a guideline sentence was appropriate here.
Thank you.
Anything else? Any other questions?
Nope.
Thanks. Thank you.
Thank you.
Well
Keep
briefed.
writing your
Well
briefs
argued.
in that same manner, Ms. Smith.
I'll second that.
I admire Justice Scalia for a lot of reasons, but he gave us another reason to admire him because that's very helpful to
It
all
is
of us
super
to have everything right there in the brief. So, Mr. Wright, any rebuttal?
Just very briefly.
Okay.
I believe as the court pointed out, panels of this court have been applying Posey. They just haven't been ruling in the defense's favor, and maybe the right case hasn't come before it. And so I'm just asking this court to consider this case as potentially the right case given Mr. Wyndham's background. I believe Sister Counsel discussed how the trial court, his OV scores, going above, I believe it's 100 cap or something.
140 or
140, right. The trial court never said that on the record, or that I'm aware of, that it was giving Mr. Wyndham this sentence or tied it anything to, oh, hey, I see his PRVs are super low, but his OVs are off the charts. I'm going to as a result, give him this sentence. So I don't see the trial court never tied it to that. I understand the prosecutor's argument, but I think there's nothing in the record to support that argument. I guess lastly to Sister Counsel's comments about the facts of this case, I agree. They're hard to read and to look at. It's hard to look at the video. But I in terms of the other store managers holding Mr. Wyndham back, I believe Mr. Wyndham testified about this. He thought, based on his perspective, the way Mr. McElrath was sitting or on his bike through the whole situation, he thought Mr. McElrath, and you can see this video, he does reach into his pocket at one point. Mr. Wyndham cannot see this pocket is on the far side, and Mr. Wyndham testifies that he thought Mr. McElrath was reaching for a gun. And so that is why he starts freaking out, for lack of a better word, or being, that's when things become very chaotic and people are holding him back. And he thought his life was in danger at that point. Of course, the jury did not, of course, make a finding of self-defense. But again,
they were instructed on self-defense.
of course, and
So they had to be satisfied beyond a reasonable doubt that he was not acting in self-defense.
correct, and they reached that conclusion. I guess the last point I would make is, and this is again what we asked for here. There was a motion to remand it. It was denied. We're asking again for this court to remand Mr. Wyndham's case. We do think maybe more information should have been provided to the trial court so it could make a more informed decision here. And the PSIR, the sister counsel raised the PSIR, Mr. Wyndham declaring in his PSIR to an interviewer he has never met before that he doesn't have any issues, mental health issues, is not, I'd say, dispositive in my mind. Plenty of people who are abused, you ask them, were you abused? They'll say no. But then when you dig into that, well, were you hit repeatedly growing up? They're like, oh yeah. So I think someone saying I wasn't abused or I don't have this or mental health or whatever, that is conclusory, and you kind of need to dig in more to that. And that's what experts are for. That's what doctors are for. That's what records are for. So we again ask for this court to remand so that we can develop the record further, and this court and the trial court can make a more informed decision.
Thank you.
Thank
Thank
you.
you very
Thank
much.
you.
Case is submitted. Very well argued on both sides. Mr. Wright, I don't think I've seen you before. How long have you been with Sato?
I think I'm over 3 years now, maybe.
Yeah, okay.
I know. I was.
Same thing.
You look far too young to have been with Sato for 3
Oh,
years.
no. I was doing. I started. I'm 2011.
Okay.
2014 grad. So
Oh, my.
yeah. I'm
Okay.
new to Michigan. I'm 3 years to Michigan,
I
but
see.
before I was doing death penalty work in Pennsylvania,
I see.
and then before that I was doing big law in DC.
Very good to
Thank
see you. Well argued.
Big law.
Ms. Smith knows how that we all hold her in very high regard, so I don't need to
Yes. Yeah.
compliment her in that same way, but I just wanted
Very
to recognize you. So,
Ditto.
Thank you both.
all right, thank you. Case is submitted, as I said. The next two cases are related. I'll call item 2 first, docket number 371952. And that is People of the State of Michigan versus Cavante Javon Foley. Mr. Ambrose,
Good morning.
morning.
It's Ronald Ambrose appearing on behalf of Mr. Foley. And we raised a number of issues in this case. I did want to just concentrate on the one issue. The first issue in the case was whether or not the photographs were substantially, the prejudicial effect was substantially outweighed by any probative value to the case. And the reason being is the medical records in the case essentially made the point that there was a serious impairment. And with the photographs, as stated in prior argument, a picture is worth 1,000 words. And I think it was exhibit 3, 4, and 5 really evoked a tremendous amount of emotion. We have a person that's laying in a hospital bed with tubes coming out of them. In one of the photographs, there's a sign on the wall that says no skull on left side. So, I mean, all of these images, I think, were just such that should not have been admitted into evidence. I mean, pretty much that was the case. After seeing those images, I think the jury reached its verdict based on that. So I'm asking, I'll rely on the other issues in my case, in my brief, but if the court has any questions or concerns.
Any questions for Mr. Ambrose? I don't think so.
Always well done. Always appreciate your advocacy.
Thank you. Appreciate it. Case is submitted.
Shorter drive this time than last time I saw you, Mr. Ambrose. We swapped. I got to drive through that.
Okay, that brings us to item 3, docket number 372035, Estate of MM versus Cavante Foley.
Good morning, Your Honors. My name is Melissa Stewart. I'm here today on behalf of the estate of MM. I'm going to keep my comments brief, but I do think it's important to stress that this is a contract dispute. And of course, a contract needs to either be enforced as it is written or construed against the drafter if an ambiguity is found. In plain language, this contract says we do provide underinsured motorist coverage for bodily injuries arising out of a driver's operation of an underinsured vehicle. And we don't provide coverage for bodily injury arising out of the use of a motorcycle, ATV, etc. In this case, the vehicle is a dirt bike. So the fundamental question before this court is, where do my client's injuries come from? Where do they arise from? And we don't need to look any further than the defendant's own admissions to find that my client's injuries arose from Mr. Foley's negligent operation of his underinsured vehicle. It's admitted on page 5 of the transcript. from the lower court hearing, and it's also admitted on page 11 of the brief. It's acknowledged by all parties. It is from Mr. Foley's use of this underinsured vehicle that my client's injuries arose. But these admissions notwithstanding, the defendant is arguing the fact that my client was on a dirt bike somehow should supersede the fact that of Mr. Foley's actions relative to my client's injuries. But that's not what their exceptions say. The defendant is looking to exceptions 5 and 6 of its contract. And both of these exceptions say that if the injury arises out of the operation of the dirt bike, then my client isn't entitled to underinsured motorist benefits.
Had your client not been operating the motorbike on the city streets, this would not have happened, correct?
No, I mean, if he had been operating a bicycle, it could have happened. If he was on a
Could have,
skateboard
but it
on his
wasn't.
feet.
He was operating a motorbike, which is an excluded mode of transportation under the UI and the uninsured motorist and underinsured motorist coverage.
Your Honors, the using the motorbike does not, they're not saying using the motorbike. They're saying or arising out of the use of the motorbike. But our position is that the motorbike itself is irrelevant because the injury arose out of the use of the underinsured vehicle. If he had been walking, if he had been in a car, if he had been on a bicycle in the exact same position at
He'd
the
be-
exact
yep.
same time,
He'd have coverage. Yes.
correct.
Yeah. Okay.
If
But he wasn't, he
but-
was operating a motorized, he was operating a motorbike that's talked about in the insurance contract that says we're not going to cover these things. Maybe because their underwriters say when people ride motorbikes, they get hurt a whole lot more. So we're not going to cover those things. And it's a contractual benefit. It's not a statutory benefit. It's a contractual benefit.
I agree that it's a contractual benefit and I agree that he was on a motorbike. But the issue is not that he was on the motorbike. It was what the accident, where his injuries arose from. Did his injuries, and defendant itself agrees on multiple occasions, the injuries arose from Mr. Foley's operation of the underinsured vehicle. If the motorbike itself were the issue, then defendant could have written its policy, or I'm sorry, exceptions 5 and 6.
Well, even under your logic, the injuries at least equally arose from the operation of the dirt bike, didn't they? I mean, it's at least a 50-50 proposition. It arose from the operation of the underinsured vehicle, the motor vehicle, and the operation of the dirt bike. You know, and maybe, you know, if we want to get into fault, that whole different thing, but you know, it's at least 50-50. The injuries arose from the use of the dirt bike just as much as they did the use of the driving of the underinsured vehicle that your client struck.
Respectfully, Your Honor, I would disagree. There's nothing in the record that indicates that my client was doing anything illegal. He didn't lay down the motorbike, which then caused its injuries. He wasn't speeding, he wasn't swerving, he was driving. Had he operated the motorbike in some sort of negligent way, then you can talk about the injury arising out of the operation.
Talk about negligence here. I mean, we have a no fault state. We're in a no fault environment. So why does the negligence aspect even come into play? Is that because it's, as Judge Redford correctly pointed out, a contractual benefit? So
It's
now
a
you get to
contractual.
sneak negligence into the equation.
Well, the contract clause says if the underinsured driver would be liable for these damages and they don't have enough coverage, then we will pay. So the underinsured driver becomes liable based on its negligence. So that's where the negligence aspect comes in. If Mr. Foley had been operating his vehicle safely and correctly, and my client caused the accident, then we wouldn't be here today. So fundamentally, in an underinsured or uninsured motorist claim, there is some aspect of negligence that has to be considered. And to my knowledge, there has been no claim on the part of defendant that my client acted negligent in any way. Their only position is that he was on a motorbike. And if being on the motorbike was enough, were to shift the inquiry, then the exception needed to be written that way. Exceptions 2 and 3 to this contract are an example of where the focus would shift to the behavior of the insured. In those cases, in those exceptions, they talk about if you're on, in, getting into, or getting out of the specific kind of vehicle, then you don't have coverage. So in this case, if the defendant wanted to preclude any use of the motorbike or the fact of the motorbike being on the motorbike, then it needed to say something to the effect of on the motorbike. If the insured is on the motorbike at the time of accident, then there is no coverage. But that's not what this says. We need to look at the specific language of the specific exception that they're relying upon to determine whether my client is entitled to benefits.
Okay.
Okay. Okay, I believe that covers basically what I want to say. We're basically asking for the contract to be enforced as written, to look at the plain language and to remember that it needs to be construed against the drafter in the
I think
case of
Mr. Cook's
ambiguity.
going to argue that it the exact same way you just did. So
I have a feeling,
we'll hear from him.
I
now.
have a feeling you're correct.
You have time for rebuttal.
May it please the court, Michael Cook on behalf of the defendant, Appalachia Citizens Insurance Company of the Midwest. First, a little bit of housekeeping. I want to make sure no one thinks I'm speaking out of turn. I didn't notice until yesterday that the notice of oral argument said I wasn't preserved. So I called the clerk and they did confirm that I did file my brief timely. So I was preserved. Just wanted to make sure that that was conveyed.
I'm showing it that way.
Okay, great.
So, yeah, go ahead.
So it sounds to me, I know you've read the briefs, you have a firm understanding. It's a very simple factual scenario, right? Contract issue. Sounds like you have a firm understanding of the arguments. I just wanted to brush up on one sort of small point. And it's the argument from plaintiff that the exclusion applies only when the at-fault driver is operating the off-road vehicle. And they cite to a Supreme Court case, Milne versus Robinson, which said that these sort of vehicles can be motor vehicles. That's a statutory case. This is a contract case, obviously, and it's really important in terms of when you analyze an insurance contract, you start with, is there coverage? And only if there's coverage, then you get to the exclusions. And the point here is their argument would make the exclusion meaningless because the policy defines underinsured motor vehicle and specifically says that is not an off-road vehicle. That's on, if you have the policy with you, it's on page 80 of the appendix, continuing on to 81. So
Okay, parse that out a little.
Sure.
bit for me.
it's what I'm saying is if the at-fault driver is operating an off-road vehicle, there is no coverage. That is not an underinsured vehicle. So in this case, they were operating an underinsured vehicle, and that's why you get to the exception. The exception, to give it meaning, it has to at least apply when the insured is operating an off-road vehicle.
Mm-hmm.
Otherwise, you would never even get to that exception. There'd be no reason for that exception. Because they've already defined away the at-fault driver operating the off-road vehicle. So
As I understand your opposing counsel's argument, I think what I heard her to say in response to my question is that the injuries didn't arise from the use of the dirt bike because the operator of the dirt bike was not at fault. So it was 100% the fault of the other driver, and therefore there's no coverage because the injuries didn't arise from the operation of the dirt bike.
right, and that's sort of the causal element. And I think you've expressed, and Judge Rutherford, you expressed as well, I think the correct understanding of arise out of, that is not a proximate legal cause sort of analysis. It is a more of a but-for causation. It excludes sort of incidental fortuitous events, right? But here, the insured was operating a motorbike on the road. It was involved in that accident directly. That's enough for that arises out of language to be triggered, and that's why the exclusion applies here. If you have any questions, I'm happy to address them.
Any other questions for Mr. Cook? I don't think so.
Thank you.
Thank
very
you.
much.
Any rebuttal, counsel? Okay.
I think we have to look at the logical conclusion of this proximate cause versus but-for cause. If we are to adopt the argument from opposing counsel, then it would seem to suggest that anytime you get into any motor vehicle, there is this foreseeable possibility that you could have an accident. And so just by virtue of leaving your house, you are in a position where your the accident arises from you being on a motorbike, being in your sneakers, being on your bike, being in a car. And that is not what the case law says. And that's not, I don't believe, how the contract is written. I think the fact that the exception is perhaps written so that it's not enforceable, it needs to be addressed by their contracts department versus this court.
Okay.
Thank you, Your Honor.
Thank you very much. Appreciate
Thank
your
you.
arguments. The case is submitted. Moving on to item number 4, docket number 373-087. Alexander Kroll versus Sergei Chuikov. Mr. Gentry. Go ahead.
Your Honor, Kevin Gentry on behalf of the defendants. Looking at the trial court's motion for reconsideration order, which is what my clients appealed from. As to acquiescence, there was not acquiescence for a statutory period. It did not follow dispute and agreement, and it did not rise from an intention to deed or a marked boundary. All that's true, and all that's irrelevant under this court's case law. Killip, Sackett, Walters, acquiescence doesn't require an intent to permanently change the boundary, as the plaintiff argues. It merely requires action. If there was intent, they would fill out papers and go to the Register of Deeds. As far as the statutory period involved, we have a paved driveway and we have a retaining wall from 1994. This is a 2023 case. We have a sprinkler system from 2005. This is a 2023 case. The trial court got all of this wrong in one sentence on a reconsideration motion. There are some equities involved here, Your Honor. There's some back and forth between these parties. There's a lot of that. But as a matter of law, which is acquiescence, and as a matter of equity, which is what acquiescence is, when you look at what the people did here, they acquiesced. The predecessors, Lawrence Edwards and his father, acquiesced to the fact that over here, we're going to put this retaining wall that's on this other property. We're going to let the people, we're going to let the son, who is the predecessor for my clients, mow and irrigate and do all these things to the property. We're going to do all of that stuff. And the trial court basically disregarded it for, quite frankly, good advocacy. But that's not what the law is, Your Honors.
Any questions from Mr. Gentry? All right.
Thank you, Your
very
Honors.
much.
Thank you.
Appreciate your arguments and your appearance. The case is submitted. I think we'll be seeing you again, Mr. Gentry.
Right about now.
In not too long.
Oh, gosh.
So you can stay right there. Is it next? It is. Item 5, docket number 368-019, Titan Wealth Advisors LLC versus Donald Fairman. And we have a slew of lawyers endorsed, but only 2 of you appearing. There's a cross appeal, correct?
There is counsel take care of that.
Okay, so just to let you know, the way I prefer to do these when we have a cross appeal. Of course, you have 1 hour for your total time between the 2 of you, inclusive of the cross appeal. So just be mindful of that. I know we won't likely get anywhere near that. At least I'm hoping that's the case. So what I have appellant argue first, and then Mr. Gentry, you can respond to appellant's argument and then argue your cross appeal when you first get up, and then your opposing counsel will have a rebuttal time with respect to the main appeal and can then respond during that segment to your cross appeal, and then I'll offer you the opportunity for rebuttal on the cross appeal. Is that understood? Okay. All right. You may proceed.
Thank you, Emily Warren, for appellants, Titan Wealth Advisors, Kevin Vandenhout and Clark Harris. The main issues out of the many that we raised on appeal are the presentation of the breach of fiduciary claim to the jury, the presentation of the claim for a breach of the implied covenant of good faith and fair dealing to the jury, and then a number of other issues that sort of led to the jury being so obviously confused about how they were instructed, what their task was, and the evidence presented to them, that they returned a verdict finding an employer, my client's an employer, having had a fiduciary duty owed to employees and then having somehow breached that duty, causing damages. There is no fiduciary duty recognized in Michigan owed from an employer to an employee. There just isn't. We raised that issue on summary disposition. The trial court denied the motion for summary disposition and ruled something to the effect that there was an issue of fact, whether a fiduciary duty existed.
Wouldn't that have been a C8 motion at that point? I mean, that's what you, or I don't know how you styled, I don't know if you were trial counsel, but how the motion was styled at the summary disposition stage, but that sounds like a C8 argument to me.
I believe that we moved under C8 and C10.
Yeah.
But regardless, the trial court allowed that claim to stand. The trial court entertained a bunch of questions and testimony from various witnesses about fiduciary duties, what they mean, who they are owed to, the definition of a fiduciary duty. At one point, over trial counsel's objection, counsel for the appellees asked Mr. Harris essentially to define a fiduciary duty. He responded, and appellee's counsel objected to his answer because it was an improper recitation of the law, highlighting why we don't typically allow lay people to define legal terms and concepts. That question never should have been asked. That claim never should have made it onto a verdict form or any jury instruction, but it did. The trial court erred by not dismissing the claim for the appellee's claim for breach of fiduciary duty on summary disposition, compounded the error by allowing all this testimony, and I guess you could call it evidence to support this non-existent claim, further erred by allowing it to be on the verdict form, and then erred by denying the appellant's motion for directed verdict. Ultimately, that was the claim that the jury found in favor of the appellees. The same is true for the appellee's claim for breach of the implied covenant of good faith and fair dealing. That claim is not a standalone independent claim. It requires a breach, or at least an alleged breach, of a underlying contractual obligation. In this case, we're only dealing with written contracts. The appellees at no point identified or had anyone testify or present any evidence that the appellants breached any term of any contract between the parties. At one point, I believe it was outside the presence of the jury, there's an exchange between counsel and the trial court, appellee's counsel in the trial court, where the trial court says, this isn't a claim. You need a breach of a contract. You can't just have words to this effect. You can't just have a standalone claim for breach of the implied covenant of good faith and fair dealing. Appellee's counsel did not have a response to that. They did not present any authority to support their position. And yet the trial court denied the motion for a directed verdict, allowed the jury to be instructed on this claim, put the claim on the verdict form. And the jury was so confused by all of this that they filled in damages in the portion of the verdict form that dealt with the parties' respective breaches of contract claims and breach of the implied covenant of good faith and fair dealing. Again, that claim the words implied covenant of good faith and fair dealing never should have been uttered in the presence of the jury. As for the damages that the jury included in the verdict form, the trial was the first time that appellants heard what appellees' alleged damages were. They didn't disclose them in their initial disclosures. They evaded discovery. They filed boilerplate objections, refused to testify about what their damages were during their depositions, refused to just to remind the court, the appellees were former employees of a wealth management firm, and they were paid X commissions while they were employed by Titan. They left, took clients with them, And the,
Right, they did that because they said your clients had Series 6 and the Series 6 chapter of licenses under the SEC, not the Series 7s. The Series 7 was what was required to sell the non-liquid assets because they have much more restrictions. They're not easy to sell or disperse. And they said Mr. Fairman forged all these documents. So that's why they said that they left, correct?
that's sort of why they I'm sorry to correct the court. The allegation was that Mr. Harris, not Mr. Fairman.
You're
Mr.
right.
Fairman left.
Fairman is the
Just-
guy
yeah.
that left. Mr. Harris is the one who is alleged to have committed the fraud.
Yes, that's the allegation. Another error, the trial court before the trial started during a pre-trial hearing said, we're not having, this is not a regulatory proceeding. This is the wrong form for that. We're not going to do
Right, but
that.
do you agree that Mr. Vandenhout and Mr. Harris had Series 6 licenses and Mr. Fairman, Ms. Masson, and Mr. Henry Conley had the full Series 7 licenses?
I agree that Mr. Harris and Mr. Vandenhout do not have Series 7 licenses.
Okay,
I believe the appellees do.
okay.
Yes. But
Do
again.
you think there's a problem if somebody signs your name that secured sale of some asset, a sale of some security is made and they don't personally possess a license and they sign your name if they're in the office next to you, is that a problem?
Yes, I would think that is a
I
problem,
would think so.
but there's no, other than Mr. Fairman saying so, there's no supporting evidence that that happened.
Right, and a jury found that it did, right?
I don't actually know if the jury found that it did. There's nothing on the form. I don't know what the jury thought about that allegation.
Well, they awarded zero damages to your client, $130,000 in damages to Mr. Fairman, and then $40,000 to Ms. Mason and $25,000 to Mr. Conley and zero to Ms. Conley. Is that correct?
That is not correct.
Okay.
The jury did award the figures that you said to the appellees. They also filled out on the verdict form the damages that my clients requested. They put that in the verdict form for the breach of contract claim.
Right.
So while they
But they didn't award any damages to him.
they did.
Is that right or wrong?
I don't actually know. The jury returned for breach of fiduciary duty. They filled out the verdict form for breach of contract, awarded everybody damages. And then I believe that they decided that both parties had breached the contracts.
Right. They said your clients breached first
Yes.
and then gave them $0 and they claimed $540,000 plus in damages and the jury gave them zero.
Ultimately, yes, but they did fill out on the verdict form the amount of damages that my clients
Right. No,
requested. So
I'm not disagreeing with you, but they ended up, the verdict was for zero.
yes,
Okay.
yes.
Can I ask, there is sort of a paucity of law with respect to this breach of fiduciary duty issue in an employment context. But under these facts, if plaintiff appellees could not have pled it that way because such a claim isn't recognized under Michigan law, I'm speaking hypothetically here, I'm not trying to presage what we might conclude on that. But if such a claim is not available, what would their remedy be? Would they be without a remedy under these facts?
Well, Your Honor, yes, but that's because they didn't actually suffer any damages and they shouldn't, they prevailed on claims
Not what
that
the
didn't.
jury found.
Well, okay, the jury awarded damages, yes, but the jury awarded damages for what was a non-existent claim, the claim for breach of the implied covenant.
So here's my question. The jury found they were damaged.
Okay.
And your argument is there's no recovery for those damages because this is not a recognized claim at common law in Michigan and it's not a statutory claim. There's no statutory right to recover for a breach of fiduciary duty. So are they left without a remedy, the plaintiffs, because there's no other avenue for them to recover the damages the jury found they suffered?
I
I
suppose,
think your answer should be yes. I wouldn't be afraid to say that. But
okay, well, then Your Honor, yes, there would be other ways for them to recover their damages.
I thought you were going the other way.
don't-
Yes, there's no remedy.
Well, Your Honor, that's not my case. That's not
All
my,
right,
you know,
fair enough.
I don't know what other claims or arguments my adversaries could have made under
Breach
the,
of contract, I suppose, just straight
well,
up.
Your Honor, except that during the trial, counsel admitted that there was no breach of the contract.
Because it didn't address fraud. I mean, most contracts wouldn't, employment contracts, I don't think would say, hey, if I defraud you of hundreds of thousands of dollars, you can sue me. I mean, so yeah, it's not addressed in the contract. That I think is kind of unsurprising.
Right, yes. So regardless of why, the fact remains that the appellees they didn't respond in their initial disclosures, supplementary disclosures, or any discovery what their damages were, how they were calculated, or present any documents to support that. I understand at trial they could just say a number and it would go to the weight of the evidence and whether the jury agreed. But we asked for this information in discovery. We're not even supposed to have to ask. They're supposed to give this information in initial disclosures. They didn't do it. They chose numbers out of thin air during the trial. Mr. Fairman went from $1.3 million in damages to, a few questions later, $130,000 in damages. There's no explanation for that. The appellees should not have been allowed to withhold evidence or even just the number of their alleged damages and then present them for the first time at trial. Again, we argued that on summary disposition, filed a motion in limine. Both of those were denied. So the jury, again, is being presented with non-existent claims and awarded damages based on nothing. The remainder of our issues really deal with the numerous abuses of discretion that the trial court committed in admitting inadmissible evidence, repeatedly assisting appellees counsel with laying foundation, introducing exhibits, asking leading questions or appropriate questions, helping appellees counsel examine witnesses. It was a first for me. I had not seen that done before, and I do believe that the trial court pierced the veil of judicial impartiality. Again, one of the questions that the trial court assisted with had to do with fiduciary duties. So the jury, I think, was clearly confused. And I'm happy to answer any questions that the court has, but on our appellant issues, we ask that the court grant the appeal, vacate the verdict, and remand the case back to the trial court for appropriate rulings on claims that aren't real.
Any other questions for counsel?
No.
All right, you have time for a rebuttal and a response to the cross appeal if you wish. Mr. Gentry.
Good afternoon, Your Honor. Kevin Gentry on behalf of the appellees. At the outset, Your Honor, our cross appeal is conditional, and therefore
Right.
I'm going to rely on the brief on that.
Okay,
We're
that's
going to
fine.
focus on the issues brought by the appellants. And on those issues, the very first one, breach of fiduciary duty. There is no question that an employer-employee relationship does not give a fiduciary duty. That's Michigan law. But that doesn't mean you can't have one if you have an employer-employee relationship. For 3 years, against Professor Wellman's advice, I owned a restaurant. I paid my employees, ADP gave them the check. If I took their checks and signed them over and put the money in my pocket and then went to them and gave them their check, their money, their cash from the bank, I would have a fiduciary duty to carry that money to them. Here, the performance agreement said that Cigna paid all of my clients' commissions to Mr. Harris, who put them in his personal bank account and then paid them to my clients. That's a fiduciary duty. He's holding their money. And not only that, that's how he was able to pull out this incredible con. Because when he would get a payment from Cigna for the illiquid security that he sold, signing Mr. Fairman's name, he would just keep it. It wasn't going to Mr. Fairman, it was going to Mr. Harris. Otherwise, Mr. Fairman would have said, Skip, I don't have a client named Skip. That would have been a problem right away. This was somewhat brilliant in design, but also pretty bad. I was worried when I listened to appellate counsel that we were talking about trees instead of the forest, and then Judge Redford and Judge Goodall brought us back to the Department of National Forest here. There's a massive fraud. There is a huge fraud here. And that is what we had. We had several different ways that that fraud was presented to the jury, and they found it. They found it several different ways. The first way is the breach of fiduciary duty, and I've addressed that. The taking the money and keeping his money and then saying, okay, here's your money.
So let me focus on that part of
Sure.
it, because as you can probably tell from my questions to your opposing counsel, this is where I'm kind of focused. Fiduciary duties, we think of those, I think, most typically arising in a corporate setting. Members of a board of directors have a fiduciary duty to the corporation and to the shareholders, right? So you sit there as a fiduciary to those other interests. This is not that. It's an employee relationship. Can a fiduciary relationship arise in contexts outside of that more typical corporate setting? And if so, what would give rise to it? You point to the fact that he held the funds in his bank account. Then is that enough to create a fiduciary relationship? And if so, why?
I believe so, Your Honor, and here's why. My clients have a fiduciary relationship to their clients. They take their clients' money. They have a fiduciary duty to not invest it in Ethereum or whatever's going to crash next week.
Yeah.
That is that you assume the fiduciary duty when you take another's assets and you hold them for their benefit. It doesn't matter if they are an employee of yours. It doesn't matter if they're a buddy of yours. It doesn't matter if there's a client of yours. You assume that fiduciary duty when you say affirmatively, I'm going to hold your money, but I'm going to give you all of it. I'm going to do what's best for your money.
And then you don't.
That didn't happen here. Yeah. And that was the root of how they were able to pull this off for so long. There were double-digit clients. We don't know how many, but there were double-digit clients that this happened to, where they thought they were buying their liquid securities from a Series 7 investment advisor. They weren't. They were buying them from Mr. Harris. Mr. Harris was taking those commissions, which, by the way, are really good. That's why you got to try really hard to get a Series 7 license. He was taking those really good commissions and pocketing them. And that was a big deal here. That was most of what was going on. Now, as to the breach of implied faith and fair dealing, remember who was pleading the contract here? Plaintiffs, I'm sorry, the appellants. They were saying there was a contract here. They said that there was a contract here. And besides that, when I look at a lot of these claims here, I mean, I've never had 7 appellate issues in my life in one case. I think I'm here most days and I don't, for several cases, and I don't have 7 appellate issues. And a couple of these, the jury found nothing based on them, and they're arguing it was error. One of them they agreed to. They're scrambling here because they're trying to move the balls around really quickly. But I'm very comfortable from what your honors have talked about, that you know what the legal issues are, and more importantly, you know what the underlying facts are here. You know what this case involved. And your honor, there has to be a remedy for this sort of thing. And here the plaintiffs pled for a remedy. The trial court did not find, because there's no Michigan law that says just because you're an employer, you can't have a fiduciary duty. Didn't find that. That's not what the law says. And the case went to the jury, and the jury decided who it believed. Thank you, Your Honors.
Thank you. Any rebuttal or response on the cross appeal?
Yes, sir. Rebuttal regarding the fiduciary duty issue. The reason an employer cannot, as a practical matter, owe a fiduciary duty to all of its employees is because it first owes a fiduciary duty to the entity if it's an LLC or its fellow shareholders. And the owing a fiduciary duty means that you cannot take action that's adverse to your fiduciary, the beneficiary of your duty. So employees could not be fired or laid off or demoted. Employees couldn't be promoted because that would be adverse to an employee who wasn't promoted. Recognizing a fiduciary duty in the employer-employee context would completely change the nature of employment. There's a reason the Court of Appeals and other courts have said that there is no fiduciary duty in the employer-employee context, not just with respect to a specific contract. And it's because it's not. I believe that recognizing that duty would fundamentally change employment as we understand it. As for the money issue, I have an assistant. She gets paid on Fridays. Right now, I have her money. I have an obligation to pay her, but I'm still not just because I have her money prior to payday, as all employers do, that doesn't create a fiduciary duty.
It's a little bit different, isn't it, though, when we're talking about commissions that have been earned and under the facts of this case versus wages to be paid out on presumably an hourly basis.
Well, Your Honor, I don't actually think that it's different, but assuming that it is, there's no allegation that my client, let's say that is a fiduciary duty. There's no allegation that it was breached. Every appellee admitted that they received all of their commissions. Ms. Mason admitted that she actually was overpaid commissions and owed to Titan money. So to the extent the group production agreement somehow created a fiduciary duty in an employer-employee context owed by the employer to the employee, there's no breach of that. There's no allegation or testimony or evidence that any one of the appellees was owed money from their commissions earned while they were employed at Titan. I just my sort of last argument, I take exception to the premise that there has to be a remedy. Bad things happen to people all the time. The law does not provide necessarily a specific claim and a remedy for every slight or wrong that everyone ever experiences.
I agree 100%.
The employees in this case, they were at-will employees. Their remedy was to leave. There was a way they could have left without stealing the clients. That my client would not have an argument for why they had to remain employed. That was their remedy. They could have quit, but instead of just quitting, they defamed my clients, took clients from the firm. They did it in a way that gave rise to.
The plaintiff had an employment contract, and part of that was the no compete, no solicitation, which is, everybody who's been a lawyer or a judge. We see these all the time. They allege that your clients committed, forged one of their names lots and lots of times. And they're saying, we're out of here on April 27th or 26th, 27th, and sometime in March, the month of April 2021. They vote with their feet, they leave. But they then say, well, you guys breached our contract, so we're gonna not be bound by this non-compete thing because you're committing unlawful activity. That's their position, I think, right?
Yes, Your Honor, that's their position. But I will just inform the court, there's been no adverse action against Mr. Harris's license. The FINRA inquiry resulted in nothing. Sigma, the broker, terminated the contract that they had with Titan. They're allowed to do so with or without cause at any time. No one testified that the contract was terminated for cause, and no action has been taken against Mr. Harris's license. So to the extent there was a inquiry of any kind and the allegations of, quote, securities fraud,
Is that a matter of record?
I believe so, yes, or an absence of record, I guess. That there would be no.
So the jury knew this, and they still said, your client's breached first, and here are the damages, 130, 40, and whatever else.
The inquiry had not concluded when the trial was happening. So the end
It's
of,
not part of the record. If it's not part of the record, why are we arguing it?
I was mentioning it to the panel just to let everyone know that Mr. Harris's license has not been revoked and no disciplinary action was taken. The inquiry was ongoing at the time of the trial. I apologize. I confused your question.
Anything else for us? I think we got it.
I think-
No, Your Honor, thank you.
Okay,
All right, thank you very much. Well argued, the case is
Yes.
submitted. All right, this brings us to the last item on our 10 a.m. docket. Docket number 3, item 6, docket number 372991, Deanne Benetti versus City of Detroit. I think Mr. Fair will be arguing remotely. He represents petitioner appellant, so we will give him a moment to join us.
Good morning, Your Honors.
Good morning, Mr. Fair. I think you can give us your appearance and proceed with your argument.
Okay, for the record, Darwin Fair on behalf of the appellate. I will say to the panel that, this matter is before the court based upon what happened and before the Board of Review and the tax tribunal with the appellant acting improper. Unfortunately, this case really boils down to this issue that I know this court is familiar with, which is notice, whether it was actual or not, and then everything that flows from that. Having said that, I don't know if I can add anything more to the brief. It's pretty much spelled out my client's position. Unless the panel has questions, I'll defer unless I need to argue a reply.
Okay, any questions for Mr. Fair? I don't think we have any for you, so you can stand by for any potential rebuttal. Mr. Richard, do you have anything for us?
Good morning, Your Honors. Kevin Richard on behalf of Respondent Appellee, City of Detroit. So first page is me rehashing my brief, so we're going to skip over that. This appeal is solely about jurisdiction. Petitioner appellant, while denying she received any of the statutorily mandated assessment notices, which are provided as a matter of course to every property owner in the city, admitted, as I indicated in page 2 of my brief, in her motion for reconsideration, and also now in the brief filed in this case, that she received actual notice regarding her 2023 assessment when she received her 2023 summer tax bill. These bills are issued in July of each year. This means that she waited at least 7 months to file her appeal after receiving her 2023 tax bill. The Tax Tribunal Act states that the jurisdiction of the tribunal is invoked in an assessment dispute involving property classified as industrial by a party in interest as petitioner filing a written petition on or before May 31st of the tax year involved. Clearly, July comes after May, and an appeal filed under this provision would be untimely. However, this statute also states that in all other matters, the jurisdiction of the tribunal is invoked by a party in interest as petitioner filing a written petition within 35 days after the final decision, ruling, or determination. If it were germane to the jurisdictional issue presented, I would argue that receipt of a tax bill is not the proper triggering event for calculating the time limit for filing an assessment appeal, as this specific statute also states, contesting a tax bill is limited to correcting arithmetical errors or mistakes and is not the basis for contesting one's assessment. I would argue it was one of the earlier notices that petitioner appellant claims not to have received. But that doesn't actually matter here because we have an admission that she received actual notice regarding her 2023 assessment and delayed filing the appeal for at least 7 months. And finally, I'd like to bring to the court's attention that subsequently to the filing of our briefs, one of the cases petitioner appellant relied on in the brief, 6ARP LLC versus Township of Byron, 348 Mishap at 1, it's a 2023 case, was reversed by our Supreme Court in MSC 166-190. The Supreme Court in 6ARP held at page 8 of its opinion that MCL 205.735A is not a notice statute but a jurisdictional statute that governs when and how a petitioner invokes the tribunal's jurisdiction. The court was specifically looking at section 3 of the statute, but I believe their reasoning applies to the entire statute.
Any questions for Mr. Richard?
Yeah.
All right. I think we are good. Mr. Fair, any rebuttal?
Your Honor, let me just say, I don't think that there is much agreement with the law on this matter. It's just the facts and application of the facts. And obviously, there's a disagreement that I would rely on this court to make that determination.
Very good. Thank you very much for your arguments today. We appreciate it. The case is submitted. That's the end of our 10 a.m. call. A lot of coffee's been consumed, so we'll take a brief recess before we call the first case on our 11 a.m. docket. For your patience. That brings us to the 11 a.m. portion of our case call. Again, this is panel 2 in Detroit. I'll let the lawyers know we are very well familiar with cases. We've read your briefs. We've had reports from our staff on each of the cases. You don't need to belabor the facts. Just cut right to the most decisive legal issues and let us know as succinctly as possible why you think you should prevail in your appeal today. With that, I will call the next item on our docket. It is item 7, docket number 370166. Joseph McCoy versus Jeff Welby.
May it please the court, Brandon McNamee on behalf of the appellant, Jeff Wallaby. I want to thank you in advance for your deep analysis of this 1956 plat from an area of the state where I grew up, the Thumb. 2.5 months out of the year, we have excellent weather up there on the lake.
Right.
Oh, come on now. Global warming. It's
Hey,
gotta
yeah,
be closer to 4 months.
Lake Huron is cold.
Yes.
So this is a declaratory action, obviously. I mean, that's core. And, I love the declaratory actions because it's such a useful tool for litigants. Take a look at this document and tell us what our rights and obligations are in the document. And whether it be an insurance policy or in this case, a plat from 1956, the analysis always has to start with the document itself. And what did those people mean in 1956? And succinctly why I win is because that was never done in this case. The court never focused on the 1956 language. And the plat draws a clear line. It dedicates private roads for ingress, egress, and we separately reserve 6-foot easements on each side of the road for public utilities. And the fact that there's a utility easement here and a utility easement here on each side of the road indicates, hey, we don't want the public utility road to go in the middle of the road because we have it over here.
Well, then why didn't your client use the public easements on the left and the right to do his stuff?
So 1986, my client moved in, and you don't get to focus on the conduct of any of the parties because that was the whole idea. Let's make them out to be a bad neighbor. Let's make them out to be a bad
neighbor, but your client laid power lines and water lines in the very area that the opposing parties did. And he says there's no authority to do this, yet he had already done it.
There was private, and we're talking about a 3-inch trench for the.
Did he or did he not?
For private water lines, those were laid before he got there. He moved in 1987 because there was beach. What about
the electrical connection? What about the drain tiles? Did your client put on Charlene Drive or under Charlene Drive or under Florence Court drain tiles, electrical wires, and mechanisms to transport water? Yes or no?
Yes.
Okay.
10-foot private utilities with 10-foot line, a 10-foot water line to a greenhouse.
They're all private, aren't they? I mean, this is.
Well, it's a public utility. So the public utility is a big thing. And why does it matter? Because you have the lots on each side, right? And every time you want public utilities now, you got to dig up the road. So there was, and you got to imagine 1956, you got your water from the beach.
Right.
So before my client moved in, yes, there were water lines underneath the drive because there were beach wells. But the drafters said, we want the public utilities to go on each side of the road so that the other 15 lots can access the public utilities. Now, the defendants don't care about
The
that.
Public, you cannot put the water lines in the easement sections according to the record because they're within 7.5 feet of a power line.
No,
Is that correct or
No,
incorrect?
no, because that was fleshed out in the deposition, and it was only ever an email from a DTE employee who never testified that said, I can't say what you can or can't do. I can only advise you as to what we allow. And then guess what happened in Exhibit 8 of our motion? They installed the water lines within 3 feet of one of the electrical poles. So they literally did what they couldn't claim to have done. And in any event, the Judge Redford, the thing is though, is how do you get to examine the later conduct? You only get to examine the later conduct if there's an ambiguity. This isn't a case about what's
But
fair.
Your client is saying there should be some type of easement. This is a deeded road. It's deeded. Race notice, Michigan basic 101 property law. Everybody in the world knows that Charlin Drive doesn't belong to any lot owner. Everybody in the world knows that Florence Court does not belong to any lot owner. Yet your client seems to believe that he does, or he owns a third of it or something. Yet there is, I see nothing in the record, and I mean zero, to support the position that I don't speak for other judges, but I don't see how this is remotely reversible error, but I could be wrong, and I normally I'm not usually as candid, but I don't see how, looking at this deeded encumbrance, this deeded memorialization, that your client's position is a meritorious one. Everybody else, I may be right in a dissent if they disagree, but
It sounds like you agree with the trial court judge who said, because my client did it, we get to do it too.
No, I'm not saying that. I'm saying as a matter of law,
Okay.
that your client says you can't do all these things. There's nothing in the record or the encumbrances on this property since 1956 which support your client's position. That's what I'm saying. I do think the trial judge got it correct, the ultimate result.
So, and one of the ruling that the key ruling that the trial court made was that they said in this declaratory action, the most important count, that you're allowed to put utilities under Charlin Drive. The trial court expanded the scope of Charlin Drive, of the private road, to include private or public utilities, rendering the two easements for
Where do you
same.
think utilities are in the city of Detroit or Bloomfield Hills or East Grand Rapids or Ross Common? Where do you think they go, counsel? It's some magic stratosphere? Of course they go under public roads.
And again,
Do you agree with that? Do you think most of the sewer lines, 15,000 miles of sewer lines in Detroit, you don't think those are under public roads?
usually there are easements right next to the public road, and I think by law the state has an easement next to a public road that extends like 6 or 7 feet in each direction. So they have public utility easements next to the public roads.
But counsel, don't you? Maybe only in West Michigan they have this, but seems like every other summer, they're tearing out a main thoroughfare to replace a stormwater drain or a wastewater drain in the middle of the road. So I don't understand the argument that, oh, you can't put utilities underneath the public road.
Well, not when there's specific grants for specific purposes, right?
Let me get to that.
Yeah.
So there are easements for utility easements on either side of Charlotte Drive, on each side of Charlotte Drive, right? No one disputes that.
No, two.
Is there anything in the dedication of Charlotte Drive that prohibits the placement of utilities beneath Charlene Drive.
The public, it says it's for private roads. It's dedicated for the use of private roads. And then they dedicate specifically
Yeah.
2 easements on each side. So why would you dedicate 2 easements for public utilities on each side of the road? And that's because you gotta imagine there's lots on each side. And so they want the public utilities, just like when Detroit Edison came in, they used the public easement so that each one of the subdivision lot owners can access the public utilities. If you put it down the middle of Charlene Drive, now every time someone wants to hook up to the water, you got to dig up the driveway, which of course my client doesn't want because he's the owner of the lots on each side.
I don't think the water lines actually went under what's used as the road. I assume it's like a 2-track.
Right.
Where the vehicles, and I think from my understanding of the record, when the lines were being installed, during the excavation process, there was, material placed on the roadway, and then it was, put back, to cover the water lines. So you're not gonna have to dig up the road to do maintenance on the water line. It seems to me, because it's, the water lines are on either side of the actual roadway. I mean, Charlene Drive is 60 feet wide, and
10 feet of it's for the road.
the
Yeah.
road
Charlotte
itself
Drive
is only
on the
10
plat
feet
is
wide.
66 feet.
Yeah, and 10 feet of it's the actual road.
Right.
And they dug right next to that 10-foot section. The road was, I mean, you saw the pictures, like it was just completely dug up with a 42-inch bugger. No tracer line was dug in. So if you're on one side of the lot, you're going to have to go through the road to get to it. Or if you're on the other side, maybe the ones on the left side don't have to destroy the road. But if you're certainly on the other side, you're going to have to go through the road to access it. And there's no tracer line, so you're going to have to dig it up. All the point being is that's why the dedication has 2 separate alleyways for those public easements to go into. And again, separate grants mean separate things. And now these utility easements, which are 6 feet wide on each side of my property, they're essentially meaningless. I mean, that's a 6 feet section of property that my client, when he sells it or whoever buys those lots, they can't use that 6
Well, there
feet.
are electric utilities there, aren't there?
On one side, yes. On the north side, there's nothing there yet. So, but the point is that if you read the opinion, we don't know because the court never looked at the 1956 language. And again, the process is the process, and the process is important because in this case, the process was backwards. First, you look at the plat. First, you determine if there's ambiguity. And only if there's ambiguity do you consider extrinsic evidence. And in this case, you got to imagine what happened here on a Thursday night at 8 p.m. My client gets served with a TRO that doesn't even remotely comply with the court rules. And there's no irreparable harm. There's no attempts to serve my client with notice. Before he even has an opportunity.
It says if you go on his land, it's a trespass and you owe him $5,000,
I get it.
right?
Yeah, but what's that relevant to?
Well, you're saying your client had no notice. Your client has affirmatively said to his neighbors, if you come on my property, I'm going to charge you a $5,000 fee for trespassing.
What does that have to do with the strict requirements for a TRO? TROs are about maintaining the status quo. A TRO is, we're not going to let Jim Harbaugh, we're going to let him coach at Penn State. If everyone remembers that when that occurred, it's maintaining the status. When I'm a big football fan. When the NCAA suspended him during Michigan's national championship run, there was
Penn State game.
Justifiably so.
I was going to say as a Spartan.
We're not going to get into that.
If you want to get into it, I'll get into it.
But the idea was find a judge in Ann Arbor that would sign a TRO that would say we have to maintain the status quo. We're not going to let the NCAA. So this was the exact opposite. Let's get a determination. Let's let everyone have their day in court, and let's let them make a determination about what the plat says. That's a declaratory action. That's not what happened here. They dug the thing up, put it in the ground, and everything from there on was about ratification, about what they already allowed to do right in the beginning of the case, and that is also wrong. So this case isn't about.
That begs the question: what now?
I mean, now you remand it, and you say that
Then what?
you have to.
The water line's there now.
Yeah,
right?
the narrowest.
What is the interest your client is seeking to protect here is sort of my
Yeah.
fundamental
I
question.
mean, the interest is exactly what I said, is that the plaintiffs don't care about how the public utilities are accessed or how anyone else taps into the public water, because they're on the lakeside. They're not the owners of all the lots that run this way. My client cares because he owns all those lots.
Right.
And so that every time you're gonna have to dig them up, and that 6 feet of property,
What purpose? I mean, every time what?
because now the municipal water, so if the municipal water
Right.
runs through the public easements where it's
Right.
supposed to, you tap into that and the road doesn't have
So,
to get dug
so
up.
you're saying if he should choose to improve one of his other lots in the subdivision?
Or just sell it. So he sells it. He
Okay.
sells the lot.
Yeah.
Okay. So when he sells the lot, that person's going to need public water.
Right.
And to do public water, if the water goes in where it's supposed to go in, they see, imagine the podium is the road.
Right.
There's a public utility easement over here and a public utility easement over
Yep.
here.
Oh, we got
We
it.
get it.
Yeah. So when he sells this lot right here,
Yep.
that person gets into this lot and goes right, and hooks up to the public utilities. And the road is completely fine and no one has to go over it again. Not only that, that 6 feet has a purpose, right? It's not just 6 feet of wasteful land. But now, that person has to go this way to get their public water,
Well,
which means they gotta dig across the road
If the
and,
council-
and do it up and then connect to the road on this
Time out.
side of the road. And then,
Council,
I'm timeout. I'm in timeout.
Your client has fee simple absolute for these other lots, right?
Yeah.
Okay. He wants to sell them, yes?
At some point,
At some point.
yeah,
And
presumably.
you're saying he wants to have as a condition that if you're gonna tap into utilities, you gotta go either right or left. You can't go down the center of the road. Fair?
Yeah.
Okay.
yeah.
Why can't he make that a condition of the sale and a restriction on the deed to lot number whatever? I agree, I'm gonna buy Blackacre. However, I'm only gonna be allowed to access utility services to the left or the right. I can never use Charlotte Drive. And in consideration of that, I'm paying you $1 million, I'm paying you $50. Why can't he, as the fee holder, do exactly what you're saying?
Well, I don't think the municipal line is gonna come dig a separate line down the right side of the thing. The Harbor Beach or wherever the water's coming from, they've already dug one line. They're not gonna come back and dig
It
another
is
line.
where it is now.
Yeah,
On this side.
it is where it is. So they're not gonna come back. And plus that would be really expensive for whoever wants, even if they wanted the Harbor Beach. So
Okay.
you gotta come back and dig a line down the right side. And the second thing is, think about the property. You got a 6 feet wide easement. That's land that you can't build on that's not being used for its intended purposes. So it has value.
What's I'm still trying to figure out what the harm is, like, you know, with respect to one of these back lots that your client owns. So as it now stands, to hook up to the municipal water line, if they improved one of those lots, put a house or a cottage on it, however you might describe it, they'd have to run a line underneath the actual road.
Yeah.
To get to the water line. My understanding of the record is it took all of 12 hours to install the entire water line from the public road, the highway, down to Florence Court. So, I mean,
Did 8 months to fix the road.
what's the inconvenience really, or the burden associated with having to then run a line to a newly constructed residence or whatever?
Each time you do it, you have to dig up under the road. But it's a fairness and a right argument.
I understand.
And that's my whole thing is this isn't about fairness. This isn't about necessity. This isn't about who's right or who's wrong. This isn't about who's the bad person. This isn't about who's the
It
good
almost
neighbor.
seems like it is a neighborhood. It's a neighborhood that we all make concessions for our neighbors when they need something. That is an illegal proposition, but my point being, I mean, it's a hard, it is hard to be to find fault with this outcome when it's a neighborhood. Like,
And I think,
build your fiefdom elsewhere.
well, I
If
think.
I can, yeah.
Yeah, no, it's a valid question, Judge Rick. But my response would be the court decides deeds,
Mhm,
plats,
mhm.
and not neighborhood feuds. That's not a job for the court. And I think the court understands my argument. And that was my client's argument to the court, was that the court needs to interpret the plat. And there's a process for that, which is ambiguity. If there is ambiguity, then you go to extrinsic evidence. So this needs to be remanded and say, you didn't follow the process.
I'm glad you went back to the remand because I think we got a little sidetracked on something I was driving towards. Because I think you make an effective argument with respect to the issuance of the TRO. Perhaps that didn't happen in the way it should have, perhaps. I haven't made the final determination on that, but it is what it is now. Hang on,
What I agree.
hang on. It is what it is now, and the water line is where it is. So if it gets remanded, again, what's the remedy? We're gonna just, would your client be asking that we dig up the water line and remove it?
Well, remember when they,
What,
yeah, so when they said,
what's the point?
we're going to let you dig it up, but then we're going to let you litigate later whether it was placed in the right spot. Remember, that's what the court said. I mean, and you can, I mean, like wink, wink. We're going to let you dig it up, and then wink, wink. We'll decide whether you put it in the right place. So I'm going to hold them to that. I'm going to say, you know what? This is what you said originally. We're going to litigate and we're going to determine whether it is in the right place.
Is that what he would seek?
Yeah.
on
So
remand?
I think
Dig it up?
the TRO becomes irrelevant because they made the declaratory action that Charlene Drive allows the placement of utilities there. So that's the declaratory action, Judge Redford, that we are, I think, disagree on what is said there. I mean, it all comes down to the declaratory action. If the court declares that public utilities can be placed here, everything else becomes done. I mean, the TRO is meaningless. You don't need the injunctive relief when you have declaratory action where the judge says you can place utilities here. So the remedy is at minimum, my narrowest relief request is remand for a proper interpretation of the plat without considering extrinsic evidence, or direction that if you're going to have the extrinsic evidence, you first have to determine that there's ambiguity. Because remember, this is a summary disposition rule. The court reviews this de novo, and the opinion doesn't, we don't know. We don't know if the court made the determination that the easement, that the Charlene Drive allowed for the placement of the utilities. We don't know that because the court never said so, because the court only focused on the extrinsic evidence. And at this point, I'm going over stuff that I am confident that the court understands my position.
Yes.
And I disagree with Judge Redford on it, but I understand his position as well.
And I have to correct because the chief pointed out that the TRO, yeah, I said I agree with what the trial court did. I don't agree with the TRO.
Thank you.
Yeah, okay, thank you.
All
Yeah,
right.
appreciate
And
that.
anytime I have for rebuttal, I just briefly. back to
Okay.
reserve. Thank you.
Yeah, Mr. McNamee, we appreciate your arguments. Your opposing counsel is endorsed, but not present. So I think with that, the case is submitted, no rebuttal. Very well argued. You're an effective advocate, despite the Jim Harbaugh reference.
The only thing I could think of with the
I thought you were saying there was a TRO to require Harbaugh to work for Penn State. I'm like, man, I missed that.
That's right.
No, it was
To
it was
coach
when he
against
suspended
Penn
and-
I
remember, it was in the
I
name
caught
of-
up with you eventually.
Yeah, it was the famous Sharon Moore crying game,
That
if
is
you
correct.
remember. Okay,
Have a blessed new year.
yeah,
Bye-bye.
same to you as
Thank
well.
you.
All right, that case is submitted. Item 8, consolidated cases, docket numbers 369-903 and 374-189, TW versus Corwell and TW versus John Fox.
Morning, Your Honor. Bob Tyler on behalf of the plaintiff appellate. And I would be remiss if I didn't make one comment. During the Coach Harbaugh sign stealing situation.
Yes.
I was driving.
You have a sympathetic ear.
Yes, no, I know I do. That's in more ways than one. But driving up Abbott to go to a football game, and of course, as Judge Godola knows, it's massed with students
Right.
out on the front.
Yes.
And
A game I've heard is called beer pong. It seems to be played rather religiously on those front lawns.
There was a sheet hanging off the front of one of the houses and with spray paint. It says, "I had a better sign, but Harbaugh stole it."
There you go.
And
Yeah.
unfortunately, I did not have my phone handy because otherwise I would have taken a picture to share with all of my University of Michigan friends.
Mr. Tyler, you have two Spartans up here, so you're ahead of the game.
I'm just Jesuit educated, so I don't have it.
Well, I appreciate that. And when I was in law school, first, my understanding is I have 15 minutes, even though it's a consolidated. I don't know that I will.
Yeah, again, it's 30 minutes per side right here with both, the cases together. So,
And if I could just reserve 3 minutes.
Sure.
In case I need it.
Yep.
When I was in law school, I was fortunate enough to be on moot court, and I have to say that this case, in getting ready for the summary disposition and getting ready for this argument and writing the briefs, I felt a little bit like I was back in law school, preparing for moot court, knowing that at some point in time, if we were successful, they were going to make us switch sides. They go, okay, now argue the other side. In reading all of the cases that have dealt with the issue of ordinary negligence versus medical malpractice, I believe, and I would represent to this court, who's far more familiar with this because I know all of you on this panel have dealt with this issue in previous appeals. Judge Rick, I think you won the lottery because I think you were on maybe 4 or 5 of those opinions. But my position, and I think the correct position, is that to determine whether a case is ordinary negligence or a medical malpractice, Brian said you need 2 elements. You need obviously the patient relationship, which is not disputed here.
Right.
And you need medical judgment. In looking at all of the cases, some of which obviously are unpublished, a number of which are published, like Atkins, et cetera, it seems to me there are a few more elements that a trial court, and of course now the Court of Appeals, needs to take into consideration when they try to decide, well, under these facts, is this an ordinary negligence case or is it a medical malpractice case? And based upon the cases that have been decided, the factor when medical judgment was up in the air, one of the other issues was the person, the employee of the facility, involved in patient care? Was it somebody that was interacting with the patient and actually trying either to get the patient out of bed or do an x-ray with the patient? Or was it somebody that was removed in some other situation as what I will call an ancillary employee, not to be disrespectful, but someone like we have in this case, and that is the central processing department, sometimes called the sterile processing department. In some places called central supply, whatever.
Hold on, I'm sorry.
Central supply.
Thank you.
Yeah. When I was at State, I worked at Sparrow Hospital, and it was called Central Supply.
Oh.
But that department, its job was, and I don't mean to preach to the choir here, but its job was to, as the instruments and the items from the ORs would come back from the ORs, it was to process them. And there is, on the defense side of this, they say, well, this creates a whole nother issue. Look at Dr. Metter's affidavit where he says medical judgment this and medical judgment that. But that is not the situation here. It is also not the situation of the so-called headlight case where the issue was, well, how do you use the light? You know, what intensity you use it? Because this is not a case where we are criticizing the way that Dr. Zaltz utilized the drill. In the hearing of January 10th, 2024, I specifically withdrew any potential claim of negligence or malpractice for what happened in the operating room. So the only thing that we're dealing on is what did or should have been done and wasn't done in central processing. And as Dr. Zaltz said, central processing was a mess. And it was in a mess in large part because of the John Fox era, where they were cutting budgets and throwing out anesthesia groups, et cetera. And Dr. Zaltz testified to what he had to do to literally go down to central processing to make sure that for his operations on the next day, that he would have the equipment he needed. Ms. Coaster, who was the head of central processing during the relevant time just before Teresa's surgery, who was not a licensed healthcare person and testified in a deposition, did not indicate any medical judgment was needed. She acknowledged what a mess the central processing department was. In fact, she said, when I came back to work to head that department up, it was, quote, swimming in instruments. And that was described in other depositions where you'd walk into the department and there were just carts and trays of unprocessed. The same thing came from Ms. Tenner, who was the previous head of central processing. They indicated that that department, which was responsible to clean, sanitize, inspect, and put back into service, if appropriate, instruments that would be used in surgeries, like the one that was used with Teresa, that it was chronically staffed at 50%. It's not the way to run a railroad, as they say. So those individuals are much like the one case that was unpublished, but talked about providing a sanitary environment. And they did not provide that sanitary environment. And that was an ordinary negligence case. It is the same situation here. And especially when we have a couple of critical facts here. One is that when I obtained Beaumont's maintenance records for this particular drill, Mr. Placenti and Ms. Coaster both testified that you're supposed to do steps A through whatever. And on the data search that Mr. Placenti did, he said, I recorded everything that was in the record for this particular drill. And it shows in Beaumont's own records that they did not do everything they should have done. The question, this is not a question in this case of, well, the way they had set up how to inspect, sanitize, et cetera, is a question of negligence or professional conduct, as Dr. Metter wants this panel and the trial court to believe. Because in the original appeal, appendixes Q through S are 4 or 5 Stryker documents where when Stryker sold this equipment to Beaumont, they said, here's how you clean it, here's how you inspect it, here's how you sterilize it. This was not a situation where we as the plaintiff are saying, well, that process was wrong. You know, they should have had 2 more steps in there that would have then corrected the situation. We have accepted that what Stryker said is the way this should be handled in the central processing department was correct. Our position is they simply weren't doing what Stryker said they should do, not what the plaintiff says they should have done, what Stryker says they should have done. And then we have the testimony from the Stryker representative, Mike Karen, who indicated that the useful life of this drill was over as of 2017. And Teresa's surgery, as you know, was in November of 2024. Interestingly enough, the day after the,
2020.
I'm sorry, 2020, thank you.
Thank you.
All right.
November 4th,
Yeah.
2020.
Thanks, I appreciate it. My brain gets ahead of myself sometimes, or
Well, the
behind
fourth-
myself.
Yeah, and the 4th was the day that the striker people were there.
Right.
The day after the.
The day after. And the reason that that is important, I represent, is under the FDA rules, what was supposed to happen when a patient is injured with a piece of equipment, the FDA requires that that piece of equipment be tagged, be inspected, and a determination be made, why did this happen to the patient? That was also confirmed by the head of Beaumont's medical engineering department. Beaumont did not comply with the FDA. They didn't even, without attempting to comply with the FDA, give that drill to the Stryker rep who was there the next day, said, you know, take a look at this because something happened yesterday.
Wouldn't most, if not all of this, have required some form of expert testimony to establish?
This case will require expert testimonies.
Okay, doesn't
And-
that cut against your efforts to have this treated as a negligence claim? Recognizing that we have experts in negligence cases too, but
Respectfully, it does not, Your Honor, and here's why. The expertise is, and even if you look at Dr. Metter's affidavit, he doesn't say it outright because of the obvious reasons, but the expert testimony that is needed is not a physician, is not a licensed healthcare person to analyze this and say, why did this happen?
isn't it? I mean, isn't it just kind of inextricably intertwined with issues of medical procedure and judgment? I mean, even with respect to the maintenance of the equipment, you'd have to have some understanding of the surgical use of the equipment.
But again, respectfully, I would disagree. And here's the reason. The issues, the technical issues that are going to require expert testimony are engineering expertise. Dr. Salt said, I can't tell you why this malfunctioned. You know, it's above my pay grade.
Right.
And the people who design these and who write the instruction manuals for how to inspect them, sterilize them, et cetera, are not physicians. They are engineering types who then give the manual to the hospital. This is not a situation, as the defense wants to make, and as Mr. DeLinga argued to Judge Mattis, the doctors come in and say, we want this and we want that. This is not, again, a claim by the plaintiff that, you know, they used the wrong drill. No, this is a question that they had a drill that was 3 years past its useful life. There's no record while it showed up in ORs after Teresa's surgery, there's no record that it was ever used. And 7 months after that, when it's replaced pursuant to a Beaumont program that started in 2017, Stryker totally refurbished that drill so that it would work, as Mr. Karen, the Stryker rep, said, when he went out to talk to medical students, to residents, this is how you use it, that he could use a drill. They had to totally refurbish that drill, even though it wasn't used after Teresa's surgery. That is evidence that it was not processed properly. It was not replaced properly. And these are not medical judgment decisions.
May I ask a question?
Sure.
Are you familiar with the Joint Commission on Accreditation?
Yes, I am.
I'm assuming Beaumont is accredited, right?
My understanding they are.
There you go. So in the Joint Commission, they have all sorts of protocols that if you're going through your triennial or quadrennial review, my understanding is anyway, that you have to meet certain standards in order to get it could either to obtain or to continue to get the accreditation. Some are staffing levels. And when I was reading your pleadings, it sounded like a lot of this is about staffing levels.
At the central processing department, you're correct.
Okay, so why, along the lines of what the chief was asking, isn't that the question of how many people do you need to run this organization, whether it's in the kitchen, which is important, in the grounds, in the maintenance, or in central staffing, or the place where this device was at? Isn't that part of the whole provision of medical services?
This case, as I had argued to Judge Mattis at one point, can have both elements in it. I mean, we have on file, but in state, a medical malpractice case against Beaumont that was filed after Judge Mattis said, this is a medical malpractice and kicked this case out. I obviously, to protect my client, filed a medical malpractice case. But this case, as it originally sat in Oakland County, can have elements of both ordinary negligence and medical malpractice. And this summary disposition was granted before the end of discovery, even while some depths were pending but not taken. So you're correct, Judge Redford. Those staffing decisions, maybe they were made by medical people using medical judgment, but we don't know because discovery was never ever completed. But that doesn't mean that.
Did you need an affidavit of merit from a hospitalist or someone to say this is where the provider failed? Your position is it doesn't apply.
Based on the facts that we know at this point, that would not be required. I'm not saying it doesn't apply. I'm acknowledging that is a possibility, but that does not mean that it is not also an ordinary negligence claim here with respect to, okay, we're working at 50%. We have these instruments. And so I'm a tech. I'm not licensed. I'm a tech. Again, I don't mean that disrespectful. I worked on the assembly line in the summers at General Motors. I worked in hospitals. Okay. And it's an important job. But if once I get that piece, whether it's a fender that I have to spot well, or it's a drill that has to be processed, and even if I don't have all the people I need, I have to take that drill and do what I'm supposed to do and follow the Stryker manuals that say you do A, B, C, D, et cetera. And if I do not do that as a non-licensed healthcare person, that's not medical judgment. That is simply ordinary negligence. So there are aspects of this that would be ordinary negligence, and there are aspects that candidly might be medical malpractice. The need for experts, obviously they want to say you have to have experts, and they brought in Dr. Metter, even though he talks about all the things that should have happened in the operating room, even though that's not relevant. And they obviously are doing it from a strategy standpoint. It's a nice legal move because now if we can come in and make a defense that, you need experts on this, maybe Judge Mattis and this panel will say, oh, well, it has to be a malpractice case. But the expertise with respect to how the drill runs, what causes it to malfunction, everybody acknowledged the malfunction, the Stryker rep, et cetera. All of that is not medical. They specifically asked Dr. Saltz in his depth, do you know why this happened? He needs to know. I mean, it happened. I was there, but I can't tell you it's because of this or that. Those are engineering. Those are technical medical device questions that will require expertise but not necessarily medical expertise and certainly not medical judgment.
With respect to that, Mr. Tyler, the fact that this particular drill is no longer available to you or to anyone, I suppose, where does that leave you at this point in the game?
Leaves me with a jury charge of a presumption against Beaumont.
Adverse inference.
Inference because they did not follow the FDA requirements. And so if they want to come in and argue that there wasn't something wrong with the drill, they've got a huge mountain to get over. Because especially with the fact that the striker rep was there the day after this. You know, this wasn't a situation where they put it on the thing and the striker rep didn't show up for 3 months. They go, oh, gee, forgot to give it to, he's there the next day. So they have a huge evidentiary problem, which may, to go back to what you said, Your Honor, and Judge Redford said, the amount of expert testimony I may need may not be as much as all of us right now think I may need because of that inference. It is a huge evidentiary problem, in my humble opinion, for Beaumont. The fact that they did not follow the FDA rules. And it goes back again to what Judge Redford brought up with respect to the Joint Commission. If they're not staffing, because this whole John Fox, and I'm not sure how, from a publicity standpoint, how familiar this court is with the John Fox and et cetera, but the testimony has been and will be more so, they were running that place ragged. And then he sold it, made a nice bonus. So if they are supposed to staff at, say, 95%, Your Honor, and they're only staffing at 50%, that may be a violation of the Joint Commission, which would then be another terrible evidentiary problem for Beaumont besides the FDA violence. Having spent hours and hours going over this, I don't envy your position because you read one case and you go, you read another case and you're over here. I would simply close with this part of my argument that there's no medical judgment that was introduced at the time, at the time of the summary disposition motion, other than Dr. Metter. And Dr. Metter is a pure speculation in so many respects. And as this court knows, if I give testimony in a case and then I give an affidavit later that's different, that's not allowed. And that's in essence what happened here with Dr. Metter. While he didn't testify, we have all of this testimony that was in the amended complaint because I incorporated about what was going on in the central processing department, what was going on in the operating room, and he ignored all of that. So he ignored sworn testimony. So a lot of what's in his affidavit, if he was to be on the witness stand, I mean, it will be obviously one of my motions in limine to cut out his testimony on so much of this because it's not factually based. And again, preaching to the choir, and I apologize. You can't create a question of fact by a speculative affidavit that is not well-founded in facts. And that's Dr. Metter.
All right. You will have time available for rebuttal if you should need it. All right. Thank you. Counsel, are you splitting time? No. Okay.
Good morning, Your Honors.
Good afternoon. I think.
That's right. It is
morning?
afternoon,
Yeah, it's
isn't
afternoon.
it? Thank you. Good afternoon, Your Honors. Michael DeLinga on behalf of the defense, and Michael Cook is here with me as well today.
Mr. DeLanga, it seems to me that doctors are not trained to make quality assurance type decisions. They are trained to properly engage in, surgical procedures. And how is this case tease out that distinction for me, I guess, because it seems to me very distinct and very persuasive.
I think that doctors are trained to be able to perform medical procedures and to do quality, and they actually obviously have to do their procedures and, with certain quality to be able to do that. They also are doing quality assessments all the time, whether they're seeing a patient in their office, seeing a patient in the hospital, operating on somebody. Someone like Dr. Zoltz is not going to go into an operation and perform an operation on one of his patients unless quality assessments have been met. In particular, in this particular case, there's all this testimony and all these things that have been argued about the things that were happening in the central processing department. But he also testified there wasn't ever a time when what I needed wasn't available. Yeah, I had to go there and I had to see if things were going to be ready, but ultimately they were. And I, of course, would never operate on a patient with a broken drill.
Right,
hurt
but
somebody
they're
like
not, I mean, from a practical standpoint, anyone who has had any form of medical procedure, which probably is most of us, you know that the doc is going from this case to the next case to the next case. They're not going into the OR and pressing buttons to make sure a drill works properly. That's not what they're doing. They're
Oh.
relying upon others.
That's not correct at all, Your Honor.
Do enlighten me then.
Yeah, so someone like Dr. Zoltz or any board certified orthopedic surgeon or a neurosurgeon who uses this equipment, they go and they push the button. And now to you and I, and this is exactly why we need expert testimony in this case, they push the button and the burr starts to turn at a certain speed. The handle starts to heat up and get a certain amount of heat in it. And they push the button. And to you and I, they're pushing a button. To them, they're holding that handpiece in their hand in a certain manner that they've been trained to do. They're pushing the button. They're listening to see how fast the burr is spinning. They're looking to see how fast the burr is spinning. They're holding that handle to see how hot that it gets. And if any of those things are not working the way they're used to have being worked, the way they were trained in their internship and their residency and their fellowship, and Dr. Zoltz in particular using this equipment for 10 years, if that's off that day, he has to say to himself, in my medical judgment, should I take this burr and put it on my patient's spine and risk it skipping across her spine and paralyzing her or hurting her? And he has to make a medical judgment to do that. And he's not just pushing a button and then I'm going to start doing this. And his certified surgical technician who tests this equipment before she handed it to Dr. Zoltz did the same thing. To you and I who don't have this medical judgment, it's pushing a button and it starts off and there goes the drill. But to them, how fast is it moving? How much is it vibrating? How much heat is it putting off? If it's not doing the way it's supposed to have been doing, then this drill should not be used. And that CST is also using her medical judgment. And then she can go to the circulating nurse and back to the sterile field and ultimately back to the central processing department and ask the questions about, was this sterilized properly? Because if it wasn't sterilized properly, it's not going to work properly. And if it's not going to work properly, it could injure one of our patients. And our courts have held that sterilization cases are medical malpractice cases, not negligent cases. So it seems very simple to us who don't understand what's happening in that OR or what's happening in the central processing department, but to the doctors and the nurses and the certified technicians that use this equipment, it's very complex and it requires a whole lot of medical judgment and quality assurance by all of them.
How does pure maintenance of the drill itself involve issues of medical judgment?
Pure maintenance of the drill.
Right.
May not, but if you look at the totality of the circumstances, and of course you look at the law that we have that talks about the gravamen of the allegations and how all of this is intertwined, you have to look at the maintenance and you have to look at what happens after the maintenance and what was happening in the operating room. And you have to remember that in this particular case, plaintiff's allegation is not just maintenance. So maybe the person who's maintaining the drill at that one moment in the central processing department is not utilizing medical judgment. But when you look at everything that's happening in the central processing department, whether it's maintenance, inspection, assembly, sterilization, following all those things that are in the striker requirements to get this drill ready, and then putting it into a sterile wrap and keeping it in a sterile field and moving it into an operative environment where it's then used. When you put all that together and you look at the gravamen of the allegations here and the totality of circumstances, it becomes all kinds of medical judgment that is used here.
Right, but sorry.
No, go ahead.
The event takes place and the patient is injured, fair?
Yes.
You don't segregate the device, which was in the hands of your surgeon.
Right.
And it's no longer available to be looked at, tested, and analyzed. All correct?
All correct.
How did that happen?
And
Well, it's
what's the gravamen of that having happened?
Excellent questions. And by both of
Maybe
you.
even more to the point, why did it happen?
Right. And the why it happened from the testimony in this case, you have to remember Dr. Zoltz, and this is going to be, again, a huge part of this trial and a huge part of this, something the jury's going to have to consider. Dr. Zoltz says the burr on the drill suddenly changed speeds and it skipped across her bone. Dr. Zoltz also says she had extremely hard bone. And there's an affidavit from a surgeon who says hard bone is what causes the main reason why a burr like this would skip. So Dr. Zoltz, although he says it suddenly lost RPMs, he's the only one who says that. And he says, I gave it to someone else and they should have taken out of circulation. But the person who he handed it to didn't testify that he said, this drill's not working. She said, he handed me the drill and said something happened. So I took the drill and I put it back on the back table and I didn't take it out of circulation. The only reason why it didn't come out of circulation is because Dr. Zoltz didn't tell anybody that the drill didn't work. He decided to put that in his operative
Knew there
report.
was a bad outcome, though.
Yes,
They
they all
couldn't
knew.
anticipate that there might be litigation involving this. Your client couldn't have anticipated that.
I'm sure that Dr. Zoltz anticipated that. And I'm sure that when Dr. Zoltz wrote the operative report and put in the operative report that it happened because of the drill, not because of his medical judgment and him deciding to continue to use that drill, when the handpiece of that drill heated up and he testified he could feel extra heat on that handpiece through 2 pairs of gloves that he was wearing that day and holding it with 2 hands, when other experts say you only hold it with 1 hand. And he says, I'm holding it with 2 hands through 2 pairs of gloves, operating on someone who has harder bone than people normally have. And the drill gets hotter than it normally got. And then it skipped across her hard bone. And then he hands it to someone and says, something happened. No one in that room. There's 2 other doctors in that room. There are multiple nurses. There's a certified surgical technician. No one else confirmed that it skipped across her bone because the drill didn't work. He's the only one that says that. He doesn't have anyone to corroborate that. And the people that he handed that drill to didn't take it out of circulation because he didn't provide that information to them. And for purposes of what's going to happen at trial, I understand those are issues for Beaumont, but for purposes of what you're going to decide in this appeal today, the more important issue is that because that drill wasn't taken out of circulation, it was then used multiple times in operations after this. And
What evidence in the record corroborates that it was used? Not that it was in a surgical suite, but that a physician used it on more patients after the plaintiff in this case. Cite and page, please.
Sure. If you look at Appendix M as in Michael and Appendix N as in Nancy, there is briefing that was done at the trial court level, and there's exhibits that are attached to that. These are the deposition testimony of Honorado Placente and Christy Coaster. And what they did
What
is.
page of your appendix, please?
And is that appellant or appellees? Because yours are numeric.
Yes, it is in appellant's appendix. I apologize, Your Honor, I do not have the page number.
M and N, at least
Yes.
we know. So, okay.
So there's deposition. So they explain both at length in Chrissy Coaster's deposition, which is Appendix M, and then it's Exhibits 6 and 7, and Appendix N, Exhibit G. They have barcodes on this equipment, and the barcodes allow them to say follow this drill through different procedures. So they testified how the barcodes have been looked at and the documentation they put together then tells us which operating rooms the drill was then in afterwards. Which again, doesn't answer your question yet, because now we know the drill was in, I think based upon those documents, was in 6 or 7 different operating rooms. But a drill can sit on a table in an operating room and never be used. The 2 best examples that I have for you is also in Appendix N, where there is operating room notes, one from November 24th of 2020 and one from November 17th of 2020. They are both from Dr. Zolt's procedures. So the same surgeon who says this drill did not work on the day in question used it on 11/24/20 and 11/17/20.
It was in fact used on those days.
So what I can tell you to be very precise is he performed an operation on 11/24/20 where he decorticated bone.
Okay.
And the only instrument that was in the operating room he could have used to decorticate bone is a drill, and this
So
was
he
the drill that was
himself
in that
used
room.
it again.
He himself used it without issue.
Okay.
And on 11/17/20, he used it to prepare screw holes, and he testified in this case that he used this drill to both decorticate her spine and to prepare drill holes in the procedure he performed. And that's at issue at 11/30/20.
Okay.
So he used it twice. Other people had it in their operating rooms. When you put Appendix N and M together with, and that's the problem that we've had in this case, a lot of people have talked about, well, the first part of those documents from Coaster and Placente don't prove the point with the drills were used, but when you put it together with the operating room notes, you can see what those doctors were doing. That drill was in the room being used.
That begs the question in my mind, because opposing counsel has mentioned that discovery hadn't closed. And I'm wondering if you can talk at all about that and whether there's a need to revisit these issues after the completion of discovery, when all is known to both.
Discovery hadn't closed, that's correct, but a whole lot of discovery had been done. I did something like 15 depositions and the trial court we did, I think, 2 oral arguments the first time, 2 oral arguments the second time, supplemental briefing. He was very, very thorough and judicious about this. So he had all kinds of information in front of him, and he certainly had enough information to look at the case law. Again, talks about the totality of the circumstances, alternative causes, right? So if, and in answer to Judge Godola's question and your from what came earlier, if you want to narrow this case down and say, tell us when one person was doing some maintenance on a drill in the CPD, in October 15th of 2020, was that person using medical judgment at that point? They may have been, they may not have been, but that's not what the law is. The law is look at the totality of circumstances, look at the alternative theories. And the trial court had enough information about all of that when you take everything going on in the CPD, everything in sterilization, and everything in the OR to make a determination that I've got enough evidence right now to determine that medical judgment is necessary. The jury's going to need to hear from experts to understand why this drill worked or didn't work. And if it didn't work, why didn't it work based upon all these different circumstances and things that are in play here. And the medical judgment and the affidavits, both from Dr. Meter, our expert, and they have an expert who is a PhD nurse who signed an affidavit when the very first case was filed. When they filed a case and said it's negligence, they still had a PhD nurse who said there are standards of care that were breached by the nurses in this case because of their failure to make sure that this equipment was ready. So we've got multiple experts already testifying during the course of discovery, and he had enough information to rule there's medical judgment by the nurses, there's medical judgments by the CST, there's medical judgment by the doctors involved in this case. And I think there's also even some medical judgment in the central processing department.
Yeah.
Your response to Judge Rick's question dovetails to a question I would ask. Change hats. You're now the plaintiff's lawyer. What does an affidavit of merit in support of a medical malpractice claim in this case, what does it look like?
It probably looks a lot like the affidavit that they don't call affidavit of merit, but it is from their PhD nurse that they had signed and submitted in the beginning of the case when it was very first filed as a negligence case. It talks about staffing issues. It talks about sterilization issues. It talks about what happened in the operating room to keep the drill in the sterile field or not keep the drill in the sterile field. It talks about what happened in the operating room with Dr. Zaltz and the residents who were actually performing the operation. The many things that occur in the central processing department, people want to say they process the equipment, right? And we were told to look at the information from Stryker so you can see how simple it is to process this equipment. There's no medical judgment there. Well, this is plaintiff's appendix that was pointed out to you earlier, P, Q, R, and S. And it's, I have page numbers for you too. It's pages 88 through 143. Also appendix T, Q, R, S, and T. That's that information from Stryker where arguments are being made to you. There's no medical judgment here because look how simple this is. But what Stryker actually tells people to do is to follow very specific requirements in getting this equipment ready. For example, you can't just take equipment like this and clean it with anything. You have to clean it with certain things. You have to get materials off of it, skin, bone, blood, things of that nature. You have to use instrument air. Instrument air is a method gas that falls under general requirements for medical gases as defined by the National Fire Protection Association and the Healthcare Facilities Codes. It's going to require all kinds of expert testimony to explain to the jury whether the CPD was using the right kind of air to clean this equipment. Stryker says that the useful life of this equipment, remember that's a big issue in this case, one of the claims, and that would be part of the affidavit too. Did this equipment go beyond its useful life? Stryker says in determining whether this equipment is beyond its useful life, the method and duration of each use is the most important. Well, who knows about the method and the duration? The neurosurgeons and the orthopedic surgeons who are actually using it. They're the ones that say how long they use the drill. They're the ones that have the methods. Stryker also says that when you click that button in the OR and you turn it on, or when you click it any other time, you should check for unusual sounds, vibrations, and or burr whip, and note the operating speed. So again, this isn't me clicking a pen, it's working. This is Dr. Zaltz clicking a button, and as a board certified orthopedic surgeon, he's saying unusual sounds, vibrations, burr whip, and this is Stryker was saying what you should be looking for. Stryker also says anybody using this equipment should read these instructions. So again, it's intertwined, everything happening in the CPD and what Dr. Zaltz is doing in the OR. Dr. Zaltz, you should read these instructions. And when you're reading these instructions and you're inspecting that equipment, Stryker says, make sure the distal tip and or body of the handpiece are not uncomfortably hot to the touch. He testified, I'm wearing 2 pair of gloves and it got hotter than usual.
Are we talking about the gloves to prevent contamination? So basically thin plastic gloves?
No, these are thick gloves that he uses in the OR to hold on to. These are not the rubber gloves that we're used to for contamination in a sterile field. The Stryker instructions also talk about that when they have warnings in there to the central processing department about making sure that you always follow the recommended duty cycle to prevent the equipment from overheating. You have to monitor heavy side loads. You have to monitor long operating periods to prevent overheating. And when you're operating the handpiece, do not actuate the attachment collar, because if you actuate the attachment collar, it will suddenly stop or change speeds or overheat the handpiece. These instructions also have different things in there about patient warnings and things not to do and to do with the equipment. It says only trained and experienced health professionals should use this equipment. Before using it, make sure you read all of these materials. Healthcare professionals performing any procedure is the one responsible for determining the appropriateness of this equipment and a specific technique for each patient. And lastly, always allow the equipment to reach the specified operation temperature range before use. So these instructions that have been submitted to you by plaintiffs as part of their appendix to say, look how simple this is, goes back to the entirety of the case, the alternative theories that we've put forward as a defense. Then you have to look at medical judgment. We're absolutely going to need medical testimony here about why this drill overheated on the day in question, why it skipped across her extra hard bone, why Dr. Zaltz used it longer than it's normally used, what the people in the central processing department did when they decontaminate it? When they got the blood that was on this drill from the last procedure, the tissue, the bone, did they decontaminate it properly? Did they clean it properly? Did they remove all of that bioburden appropriately? Dr. Meter says that's all calls for medical judgment. Did they process that drill, that handpiece correctly? Did they inspect everything correctly? Did they remove the additional bioburden? Did they follow all these Stryker processes? Did they use the right kind of air? Did they use the right kind of abrasive materials and non-abrasive materials to clean this? Did they then sterilize this equipment correctly? And then once they sterilize, that's all central processing. There's all kinds of medical judgment there. Then it moves onto a case cart where it has to remain sterile for the entire time, and moves into the OR where it's put on a sterile table and kept in a sterile field, then tested by the surgical tech for these sounds that Stryker talks about, then tested by Dr. Zoltz, then used. And if that wasn't enough, you have the additional part on top of that where he says, I used it longer than usual and it got hotter than usual.
I think we get it. We're kind of retreading
Thank you.
old ground here. Anything else?
You know, just apply that to all the case law, and that's why you look at the totality of circumstances and the medical issues are there. We have not touched upon the second issue, the fiduciary duty at all. All I can essentially rely on the briefs, and just to say that clearly a fiduciary duty claim is fiduciary duties of executives, are a fiduciary duty that they owe to a corporation, not to a member of the general public. Case law is replete for examples of that. And plaintiff has tried to sidetrack that by using this Blue Cross statute, which applies to Blue Cross only. And so there's no breach of fiduciary duty argument here. And I would ask you to affirm the lower court. Thank you very much.
Thank you. Mr. Tyler, you do have a few minutes left.
Thank you. As to the fiduciary duty, it's not a reliance upon the statute. The Warren Tool case, which I cited, and if you read the Warren Tool case, it cites a handful of other cases, all say that management type personnel in a corporation can be held personally responsible for their torts. Yeah, and it was in the brief, they said, well, you're going to hold the CEO of Ford if they drive an escape and something happens. I can tell you because I do an awful lot of product liability crashworthiness case. When the Pinto happened, the executives went through and said it'll cost us X to recall these and fix it. It'll cost us less if we just pay off when everybody gets burned up. And that's exactly what they did. Those executives, for their torts, not the corporation's torts, their torts can be held personally liable because they have a duty. The New England compounding, which this court may recall, I was involved in those cases. Those the heads of that company actually went to prison. They were criminally prosecuted, but they also were held civilly liable for their decisions that they made. So I submit that there is a fiduciary duty and that part should be reversed by this court.
What tort do you think the executive that have you pled that the executives engaged in? What tort?
I did with respect to the complaint where I incorporated all of the testimony and where even like Dr. Saltz talked about how when John Fox and his crew took over, they were throwing out groups. They were not staffing. It's undisputed that central processing was staffed at 50%. All of those cutbacks then led, and we haven't taken Mr. Fox's step yet, all led to selling it to Spectrum, and Mr. Fox made a whole bunch of money off of it.
Let's assume all that's true.
Yes.
What tort did Mr. Fox or others who you've indicated in the complaint, what tort did they commit?
A violation of their fiduciary duty to the patients that were going to be affected by their decisions to not staff it properly.
Okay, so so like the Ford executives in your Pinto example, they made a economic based decision that we're going to accept reasonable losses because it's economically advantageous for us to do.
Right.
Okay. All right. Thank you.
With all due respect to Mr. DeLinga, he sometimes conflates his opinion of facts with the facts that are in the record. And I obviously am required to call that out. With respect to this mysterious event that happened, and to go back to Judge Gondola's question, why this drill wasn't set aside, Mr. Delinga's statement is, well, nobody really knew about it except for Dr. Zaltz. That is totally inconsistent with the testimony. The other two doctors who were residents both testified they were aware that something happened. More importantly, Dr. Zaltz told them to go to another operating room to take care of another patient, and he called in another specialist surgeon to help him correct Teresa's injury. So this was not like a normal operation. Oh, here, take this drill. You know, I got to do some stuff. Everything's fine. This was a situation where they were stopping in an operation and the residents were leaving because they knew something had happened. And Dr. Zaltz is saying, get a hold of Dr. Khalil to bring him in here because I need him to help me on this. So this was not a mysterious, unknown event.
But your opposing counsel's position is that there was no indication that this was the fault of the equipment at the time. So, I mean, it would be as if in a surgical context where you're doing open heart surgery and you're using a scalpel and clamps, and there's a bad outcome of the open heart surgery. So long as no one says, yeah, the reason that happened, that bad outcome happened, was because of a faulty scalpel or clamp. So there wouldn't be any reason to take those out of circulation unless someone who was in the operating room said, we had a problem here during this surgery, and it's because of equipment failure. So how is this any different?
We look at Dr. Saltz's testimony. Dr. Saltz said, I gave the drill over to the nurse. I said I needed a different one. Dr. Saltz testified, it's in his deposition, that is obviously notice that there's something wrong with this drill when I'm swapping it out in the operating room to finish
Is
the
it true that
operation.
he himself used it in subsequent surgeries?
Well, I was going to address that.
Okay.
Dr. Saltz's testimony was taken and Mr. Delinga's office was there. Beaumont was represented. They never asked him in his deposition, well, Dr. Zaltz, isn't it true in this operation that you use this drill? Isn't it true in that operation that you use this drill? We have not only the operative records of those other operations, we have the records that show that the drill ended up in ORX. There is nothing in any of those records where it says that the drill was used. And if they want this.
Well, why can't we draw that inference based on what your opposing counsel argued? A very almost what sounded like an almost identical procedure to the one at issue here. And that was the only drill in the operating room at the time with Dr. Zaltz.
That's the key word right there, the only drill. There in the operation with Teresa, the records show there was more than one drill. So the fact that that drill shows up, that it showed up there and he's doing a similar operation doesn't exclude that another drill was used. And when you look at the processing, when it comes back from that, let's say, second operation with Dr. Zaltz.
It's there for a reason, that drill. And he's in the operating room with the same drill on two other occasions. And if he has to do all the things with respect to that we've been told he would have to do, in other words, test out all the equipment before he begins the procedure, I mean, wouldn't he pick that particular drill up and say, hey, wait a minute, this is the one that failed the last time I used it, get it out of here. But that didn't happen, did it?
Well, a couple of things. I understand
whether or not he actually used it.
Yeah, I understand that when you look at that, you say, well, maybe an inference could be drawn, but let's juxtapose that to the fact that his testimony was taken. If in fact they believed that he had used that drill in these other operations,
And they never asked the question.
why not ask him and get it on the record as opposed to asking Judge Mattis and this panel to, well, maybe he did.
Okay.
Right, yeah, you were at the dep. Why didn't you ask him, did you use it?
You know, my memory of his testimony, I don't want to misstate anything. My memory of his testimony is he communicated with the central processing after this. He was expecting somebody to get back to him to say, okay, well, we looked at the drill because, you know, the normal routine, and nobody ever did, and the issue just sort of faded away. And so if in fact, go back to Judge Godola's, you know, the possible inference, and I understand that and I respect it. Dr. Saltz testified, he's waiting for somebody to come back to him to tell him what happened to this drill. And, you know, I put it aside, had it put aside. If he then is waiting for that answer and that drill shows back up in another operation, isn't that something that he's going to bring up? I mean, again, talking about
I
inference.
think that's my point, but I don't see that happened.
I-
It showed up again and in the operating room and he remained silent apparently.
But appreciate, Your Honor, that there are lots of things that come into an operating room from central processing
Sure.
that are never used.
Right.
Some of them aren't even unwrapped. So the fact that, you know, you got a tray full of things over here and it's there, and that was the reason I went after that discovery, is the fact, okay, you Beaumont say this drill was used later and everything was fine. So I said, show me the records, and I got an order for redacted records, not only of the central processing, but also of the actual patients and the operations. And it never says in there that
This
this
was
drill
used.
was used.
Okay.
The other-
Anything else for us? I think we're,
I do have one.
Yeah,
question,
please.
Chief. It sounded like you were going to say something along the lines of, oh, and after the surgery, this is what we saw in the drill itself. I mean, or was I reading something into something?
No, we candidly, Your Honor, do not know what was in the drill afterwards, because that drill is.
Okay, so you don't have some report that says it goes back after surgery number 3 and it's still in the surgery, it's still in the sterile container. You don't have evidence of record like that.
There's evidence that it went into other operating rooms, but in the operative reports of those other operations, there's no indication it was used. There's no record where I think Your Honor may have been going, when that drill goes back to central processing and gets put back into the mix without it being done per the FDA, the records do not tell us that, well, we inspected this drill and we found X or we found Y. It just,
Okay.
it is just mundane as to what goes on.
Thank you.
If I may make two really fast points.
I'm afraid your time's expired. So I think we have a firm grasp of the issues and the facts. So we will endeavor to render a decision in due course. So appreciate your arguments. It was
Thank you
well
both.
argued on both sides.
Yeah.
And the
Appreciate
case
it, Your
is
Honor. I
submitted.
would ask that it be reversed and opportunity to go back.
Right, understood. We know what
We
you're
were pretty
really.
sure that was
We know
where you
what
were
your
going.
requested
I was
relief
pretty
is.
sure you
But
knew
since
that.
there wasn't
you
a
know.
record of it, yeah.
Right.
Just wanted to make sure.
We would have granted
Absolutely.
relief, but the lawyer never told us what to do.
He never said what he wanted, so why should he give me?
Okay. Thank you.
Thank you. Your Honor.
You bet.
Seriously.
Mr. Tyler, I look forward to running into you at Spartan Stadium next fall.
Well, I went to the basketball game last night.
I wish I could have.
Oh
I
my
was here.
gosh.
I was here.
Well, I spent a bunch of days getting ready for this argument, so I said, I'm gonna treat myself and go along.
You saw a good one.
And Fitzgerald's there with a bunch of obviously transfer.
He was.
recruits.
Yes, he
So,
was.
Okay.
What do
Yeah.
y'all think of the new coach?
Oh, very positive. Good hire. I think everyone's excited for it. Yeah.
I think based upon all of the chaos that's going on with the state, all the other coaching
Right.
jobs, I thought we
Did very well. I agree with you. 100%. Yeah, he's a good hire. We'll see.
That's, we've been there before, right?
Right, exactly.
The Tiger saying, restore the roar.
Yeah, yeah.
Let's see, Michigan State, Michigan Big Ten Championship game.
Yeah, maybe that'll be in the office.
That'd be nice.
Okay, case is submitted. Thank you very much.
Thank you, everybody. Have a good day. Thank you.
Yes, you too. Okay, I think that takes us to item 9.
Yes.
Okay. Docket number 374573, In Re TEB. And a respondent appellant's counsel is not endorsed, so we will take your appearance and any argument you wish to make.
Thank you, Your Honors. Good afternoon.
Yeah.
Jennifer Bruggeman, Lenawee County Prosecutor's Office. Any Montana State fans? They just won the
They won the
national championship last night. Yes. I am from Montana and went there for undergrad, so
Did
it's
you?
that was
Wow. I have two
exciting.
friends who have children who both at least attended Montana State. I don't think one earned his degree, but the other did. So, and I've it's in Bozeman.
Bozeman, yes.
And I've seen the football stadium.
Yes.
My wife and I took a trip out west a few
Cool.
summers ago. And
We
so
went to
we
a deep
flew out
freeze.
of Bozeman, and so I said, I've got to go to the football stadium. So
Yeah.
that's great. Got out of the car and you can peer
Did you watch
right
the
in
game?
there.
I watched until halftime and I wish I would have watched all the way through because
Guess
it
it
went
was a
into
thrilling
overtime
game.
and
Yeah.
yeah, 35-34 and yeah, pretty exciting. I did have friends that went and wish I
Where
would
was
have,
the game?
in Nashville.
Oh.
Yeah.
Right? Gosh, great
Yeah.
time.
So that was pretty cool.
Congratulations.
What's the name of your mascot?
The Bobcats.
The fighting butt.
Yeah. And they have, U of M colors. So
Oh, they
Okay.
do.
I don't know
But
how
they
you feel about
defeated
that.
the U of M of Montana twice, once during the regular season and then
Yes.
again in the playoff.
right,
Is that
which was
right?
unusual that they
Very-
had to play in the
Right.
playoffs.
That's what Indiana's gonna have to do in a couple nights, right?
Oh, really? Oh, I
Play in
didn't.
Oregon.
Oh, yeah. I should know that. I went to Oregon Law School. Yes.
Oh, did you?
And
Okay.
they're playing in Atlanta, right?
I
believe.
so.
Yeah.
Yeah.
So,
Okay.
Yeah.
Now, we'll hear
Okay.
your argument if you.
well, as I won't belabor everything because I think one, I would argue again that this appeal is moot. I know that there is different sides of that coin on whether or not to consider an appeal moot. The last appeal in this case was considered moot by the Court of Appeals. It is still pending on application in front of Michigan Supreme Court. And in this case, there was the January 2025 order, which is what's being appealed. Since the appeal, there's been 2 other orders entered. There's been a June 30th, 2025 order, a 90-day order, and then now currently there's a September 26th, 2025 order. That order, I believe, is being appealed, but the brief has not been filed yet. So I don't know what the arguments are going to be. I mean, in the long and short of it is this individual has a long history of mental illness, and I believe that the court complied with, in terms of their arguments on appeal, setting aside the moot issue. I don't believe there's anything that the court did that is error. But I'm happy to answer any questions. I don't want to belabor everything
Sure.
because
I think
yeah.
we're persuaded by your mootness argument, which of course is a frequent problem in these
Yeah.
cases.
And I
because
see
of
the
nature of the orders
practical
and their short
problem
duration.
there. Yeah.
Maybe the Supreme Court will give us some guidance.
Yeah.
But
Well, or
that's-
legislature or,
Right.
something to that effect, because I understand and I'm sympathetic to it. But also there's other avenues that weren't taken here, filing a motion in the trial court for, a stay,
order.
anything. There really wasn't anything to kind of push that issue to get heard right away. No motion for expedited,
Right.
so again,
Yes.
there's multiple reasons there why somebody might not do that, but yeah. So Any other questions?
Any questions, Judge?
None.
Okay, thank you
Okay.
for appearing today.
You're
We
welcome.
appreciate your patience and
Yes.
for the
Yeah,
fact
I'm
that you made
grateful
the
I'm
trip.
no longer a civil attorney.
Yes, I'm sure. Yeah. Understood. Okay, that case is submitted. Thanks again. Okay, it looks as if we'll be able to jet right through our remaining docket. I'll call the remaining cases. Item 10, docket number 373-178, In re Dunlap Walker minor. And that case will be submitted on the briefs as respondent to appellant's counsel is not present. Item 11, docket number 375-421, In re Fernald minors. That case will be submitted on the briefs. Item number 12, docket number 375-722, In re AM Schofield Ruse minor, will be submitted on the briefs. We got 4 more in which no one is endorsed. Item 13, docket number 374-284, In re Reeves Knight minors will be submitted on the briefs. Item 14, docket number 376-581, In re Dunaway minors will be submitted on the briefs. Item 15, docket number 374-780, In re Hawkins minors will be submitted on the briefs. And item 16, docket number 367-857, In re JSF Abbott minor will be submitted on the briefs. And with that, we are in recess until 10 o'clock tomorrow morning.